Mr. Miller and Mr. Berman, if you have an opportunity to test your audio and video, you could do so now.
Testing the audio and the video here.
Thanks so much.
Are you still there?
Yeah, can you try your video? Looks great. Thank you.
All right, thank you.
Good morning. We're now on the record. It's 9 a.m. on November 21st, 2024. This is an evidentiary hearing in proceeding number 24A-0380EG, Public Service Company of Colorado's Excess Liability Premium Assurance Deferral and Tracker application. I'm Eric Blank, and I'm the chair of the commission. Can my colleagues introduce themselves for the record, starting with Commissioner Plant?
Good morning, everybody. I'm Commissioner Tom Plant.
Good morning, this is Commissioner Megan Gilman.
If we can go through entries of appearance, starting with the company.
Tyler Mansholt on behalf of Public Service Company.
Trial staff.
Good morning, Commissioners. Assistant Attorney General Ross Smith. I'm joined today with co-counsel Josh Horman and Justin Larson.
Colorado Energy Consumers.
Good morning, Mr. Chair, Commissioners. Michelle King of the law firm Holland and Hart, and joining me as co-counsel is Christine Roche. Here on
And
behalf of the Colorado Energy Consumers, if I didn't say that.
thank you. Commission counsel.
Sorry to interrupt. Kate Crampton with the
Oh,
Attorney General's office on behalf of the Utility Consumer Advocate. I am solo today in terms of counsel, but I'm here with UCA witnesses, Ms. Henry Sermos and Mr. Fernandez.
my apologies, Ms. Crampton. You're right there on my list. So my mistake. Commission counsel. Oh, I can't hear you.
Chair, I can enter appearances.
Yeah.
I'm Assistant Attorney General Wendy Rosati, and I'm joined by my colleague Wyatt Foreman, also an Assistant Attorney General.
Thank you. Going to exhibits, we're going to conduct this hearing using electronic exhibits. A spreadsheet marked as a hearing exhibit 600 lists the latest versions of the pre-filed testimony and attachments. Any objection to the admission of hearing exhibit 600?
No objection.
With that, hearing exhibit 600 is admitted. Any objection to admitting the documents and other attachments and filings on hearing exhibit 600?
No objection.
Hearing none, the exhibits are admitted. Looking at this cross-examination matrix with more time allocated than we have hearing. Given the commissioner's schedule, I do not think we're going to live with this cross-examination matrix. So have the parties fixed it and made it something we can live with, or does the commission need to address this?
The parties don't, in a comprehensive fashion, have a proposal to present. However, the company does have some adjustments itself to hopefully assist for its own part.
Fire away.
We will waive cross-examination of CEC. And we will also reduce our 15-minute reservation for staff's witness to 10 minutes.
All right, and my proposal for the rest is to cap each of the three other parties at 45 minutes total to try and get this hearing in today, given the commission's schedule. So I throw that out there. Mr. Smith?
Thank you, Chair. I would just like to perhaps add some assistance to this. Staff is going to waive its cross of company witness Miller, which should free up another 30 minutes.
All right.
And if it's helpful, UCA had reserved 40 minutes for both Mr. Berman and Mr. Miller. I do have questions for both of them, but I expect Mr. Miller will be more like 10 minutes.
So that would help as well, I think, with the timing.
Ms. You seem to be the can you help clarify this unknown witness? Is the witness known, at least to the parties?
We don't have a witness, and Public Service Company reserved that as if we're resource constrained in this proceeding and weren't able to retain a witness. And so I can't quite speak to why there was cross reserved for CEC for a witness that doesn't exist. So to the extent that helps, we'll leave
It does help.
and then beyond that, given the adjustments that the parties have made, I think we're well below now the 4 hours reserved for this hearing. I'll certainly do my best to minimize the cross that I have and avoiding duplication. However, I see that as something of a due process concern to be constrained to 45 minutes, particularly to have that be offered on the day of hearing when preparations are already underway. This is a weighty issue for the commission and there are high stakes for ratepayers. And so we'd like to be able to be heard. That said, I don't want to waste the commission's time on anything. I do think, as far as my reservations of 45 and 45 for Mr. Berman and Miller, I think I'm going to likely have more than 45 minutes for Mr. Berman, but would take that from any time reserved for Mr. Miller. I think I will probably have an hour, maybe just over, for Mr. Berman. And if so, then maybe I don't want to constrain myself too much, but I will respect the commission's scheduling constraints. I think I'll have probably just over an hour for Mr. Berman and maybe 20 minutes for Mr. Miller. And so that still shaves 10 off the total estimate.
That's 40. Well, maybe you want to go last and see if you can adjust your cross given what UCA and staff did.
I don't.
I hear you on your due process, but there's no other hearing dates and the commission needs to be able to ask our own questions.
I certainly respect and understand that. And all I can say is I'll do my best to make this as efficient as possible.
And are you okay going after staff and UCA, or you want to go first?
I would prefer to leave the order as is and would be happy to make up time with Mr. Miller if need be. And so I can at that point evaluate the value of the questions being asked of Mr. Miller, but I would like to have the full extent of the time reserved for Mr. Berman.
Mr. Smith?
Staff would also, I agree with Ms. King in that we would prefer to keep the order as is on the schedule. And as to the extent we can assist in any way further, I expect that our cross on Mr. Berman will not go the full 30 minutes. So, I'm not trying to donate time to Ms. King, but at the same time, like I echo her thoughts.
All right. So if you can just let me write this down for a second. So so there is no CEC witness. So that saves 10 minutes on public service. Mr. Smith, you said no cross of Mr. Miller, or only 10 minutes? Can you remind me what you said again, Mr. Smith, just so I get this all down?
Oh, sorry. We will be waiving completely on Mr. Miller. I expect that we will be reducing our cross. I don't want to put a number on it, but my expectation is that we will not take the full 30 minutes for Mr. Berman.
Okay. Okay. And UCA, you said less on Mr. Miller.
Yes, we had reserved 40 minutes. Practically speaking, I think it would not take more than 20 minutes and maybe even more like 15. And if our questions are asked by other parties, we could potentially be in a position to waive as well, but I can't make that determination right now.
All right. Thank you for the clarification. Let's go to witnesses. So I guess do we have witnesses to excuse? It looks like not. Is that correct?
I believe that's correct, with the understanding that CEC is not presenting a witness.
Okay. Any other preliminary matters before we call the first witness?
The company has one issue on confidentiality to assist the hearing.
Yep.
We can remove the confidentiality designation of hearing exhibit 102, attachment RLM1.
Okay.
Just so if some party wants to discuss that attachment, we can do so in a public fashion.
Appreciated. Other preliminary matters? All right. Anything else before we call our Mr. Berman? Mr. Berman, can you hold up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Put your hand down. Is anybody with you or communicating with you in any way?
No,
If that changes, you'll let us know.
I will.
Back to you, Mr. Manchell.
Good morning, Mr. Berman.
Good morning.
Good morning. Can you please state and spell your name for the record?
Yes, my name is Stephen Berman, STEVEN BERMAN.
And by whom are you employed and in what role?
I am employed by Public Service Company of Colorado in the role of Regional Vice President of Regulatory and Pricing.
And the company filed on your behalf in this proceeding, hearing exhibit 101, your direct testimony, and hearing exhibit 103, your rebuttal testimony and attachments.
That's correct.
Are you aware of any material corrections to those testimonies?
I am not.
The witness is available for cross-examination.
Ms. King, 45 to 60 minutes.
Thank you, Mr. Chair. Good morning, Mr. Berman. We
Good
know
morning.
we know one another, but for the record, I'm Michelle King. I'm here on behalf of the Colorado Energy Consumers. I'd like to begin with hearing exhibit 101, pages 14 to 16. Specifically, if you'll scroll down, please, Ms. Kunkel, to line 17 in the discussion that begins there. And there, Mr. Berman, and in the discussion that follows, you discuss the commission's support for deferral and tracking mechanisms, similar to what the company is seeking here. Is that right?
That's right.
And because CEC members take electric service from public service, I'm going to focus on the electric proceedings. Mr. Berman, if we turn at the top of page 15, if you'll scroll down just a bit, thank you. There you discuss the property tax tracker. And as you state in lines 1 through 7, and also in footnote 2, this treatment was agreed to as a result of settlement in proceeding 14A-0380EG. Is that right?
That's correct.
And if we turn to page 16, you mentioned the pension expense at line 10. And there in the testimony from lines 11 through 14, and also in footnote 9, you mentioned that same proceeding as giving rise to this tracker. Is that right?
That's also correct. Yes.
Can we please now pull from CEC's box hearing exhibit 500? Thank you. Now, Mr. Berman, do you recognize this as decision C-15-0292 in proceeding number 14 AL 0660E, which approved the settlement that we've just been discussing?
Yes, I can see that that's what it says. I've not looked at this document in some time.
Okay, and if we can please scroll to page 25 of the PDF. There is the settlement that you refer to. Is that right?
It appears to be, yes.
Now, you rely on this settlement in your testimony as basis for the commission's support for the property tax and pension expense trackers. And so I trust you have at least some working familiarity with it.
I would, and I point out my testimony also discusses how those trackers have been reapproved in every rate case since inception in this settlement.
And we'll get to those. So at this point, though, I'll move the admission of Exhibit 500.
Any objections?
No objection.
So moved.
So you are aware, Mr. Berman, that this proceeding involved a phase 1 general rate case, are you not?
I am.
And as part of that rate case, various aspects of the company's cost of providing service to its customers and base rate revenues were considered. Is that right?
That's correct.
And it was resolved, as you note, by settlement, as is on the screen, right?
Yes.
And Public Service is one of the settling parties and signatory to the settlement. And I can refer you to a page if you need.
No, no reason to doubt that. We would be a party to the settlement.
And you have a lot of experience with settlements, don't you, Mr. Berman?
I do.
And in your experience, settlements typically represent a negotiated outcome, right?
Correct.
And it's not usually something for nothing, but rather an exchange of compromises, right?
I would agree with that.
Now, for example, if we look, please, to paragraph 1 that's on page 2 of the PDF. Thank you. And there we see that the company initially proposed to increase base rates by 157.6 million. Do you see that?
I do.
And then if we turn, please, to paragraph 17 on page 6 of the decision, we see that in settlement, as part of the exchange of compromises, the parties agreed to actually reduce rate base. In other words, a rate decrease by 39.4 million. You see that?
I do see that.
And if we turn, please, to page 12 of the decision, under section 4, paragraph 34 shows that the company's then current return on equity, or ROE, was 10%, right?
I see that, yes.
And in the following paragraph, paragraph 35, we see that Public Service requested that its authorized ROE be increased to 10.35%, and then later adjusted that to 10.25% in rebuttal. Do you see that?
I do.
And if we can please turn to page 13, paragraph 37, we see that the settling parties agreed and negotiated an ROE reduction to 9.83% as part of the exchange of compromises. Is that right?
That appears to be correct.
And are you aware that this settlement agreement also included an earnings test calling for the shared earnings between the company and ratepayers if the company earned more than its authorized return?
Again, I haven't looked at this settlement agreement in a while, but if you could point me to it, I wouldn't doubt that that was there. I recall having an earnings test around this time period.
Sure, we can go to page 20, please, paragraph 66. So now do you see that there was also an earnings test agreed to as part of this settlement?
Yes, I see that.
Thank you. And if we can please turn next to page 7, paragraph 20. We also see, and if we can scroll down just so that the whole, thank you, paragraph is showing. In paragraph 20, we see that under the terms of the settlement, the company also agreed to a rate case stay out and to not seek any base rate changes prior to a 2017 rate case with rates that would go into effect no sooner than 1/1/18. Do you see that?
Yes, I see that.
And do you accept then, Mr. Berman, that the property tax and pension expense trackers to which you cite in your testimony weren't created in isolation, but rather are among a balance of compromises, including ROE reduction, rate base reduction, an earnings test, and a rate case stay out?
In this specific case, I do, and my testimony, to be clear, is just citing to where those two, and that's two of a number of sites that I make on these types of trackers, initiated. And again, they were reapproved in other settlements and litigated cases thereafter. So these are long-term trackers that have been in place for over a decade or a decade now.
Yes, I understand your testimony on that. And even though a rate case can be where the prudence of the investments collected in the deferral is determined, here it was the venue where the fact of these single stream mechanisms was approved. Is that right?
That is correct for these two in this
Okay.
instance.
So thank you. So in any event, if we turn to please page 31. Actually, I'm sorry, it's page 55 of the PDF. And if we can please scroll down to paragraph 4. Thank you. We see there that, except as expressly stated herein, nothing in this settlement agreement shall resolve any principle or establish any precedent or settled practice. Is that right?
I see that, yes.
Okay. We can take this document down. Thank you. Now, you note, and you've said several times, that both of these trackers were continued. And in your testimony, the next proceeding that continued them was docket number 19 AL 0268E. Is that right?
That sounds correct. I don't could reference it.
If we can please pull, and I can refer you back to your testimony if you want.
If that's, I mean, that would be helpful just to refresh and see that.
Okay, if we can,
listed the proceedings there.
if we can please pull hearing exhibit 101, page 14. And if we can scroll down to the discussion on, to scroll down to line 17 and specifically footnote 2, or rather page 15, I'm sorry. And scroll to the footnotes there. You see that footnote 3 has proceeding number 19 AL 0268E.
I do. I'm just looking at, so I have this in my head on the other ones that come after that if we end up going there. Okay.
Okay. And would you like to confirm too for the pension expense, or are you confident?
No, I know that these were both at issue in all of these proceedings.
Okay, thank you. So if we can next pull from CEC's box, hearing exhibit 501. And Mr. Berman, do you recognize this as decision number C20-0096 in proceeding number 19 AL 0268E that we've just been talking about?
Yes.
And do you, and this is one of the cases that you cite to as expressing the commission's support for deferral mechanisms, including the property tax and pension expense deferrals, right?
This is the next proceeding where those two Deferrals were at issue, yes.
Okay, and so given your reliance on the decision in discussing those trackers, I trust you again have some working familiarity with it.
Correct.
And so I move the admission of Exhibit 501.
Any objections?
No objections.
So moved.
So, Mr. Berman, this too is a rate case where all aspects of the company's rate base and costs of providing service are considered holistically, is it not?
It is.
And so even if the property tax and pension expense trackers were continued, the commission had available to it other levers, such as downward adjustment to ROE, overall base rate revenues, as we've just discussed, towards achieving a balanced outcome. Is that right?
That's right. And I'll just point out here that the company seeking tracking and deferral of these costs here, and the commission will have all of those levers available to it when we bring those costs forward and seek recovery.
Right. And so in these rate cases, in this rate case in docket 19AL-268E, the commission wasn't just considering the prudence of the investments tracked in these single stream mechanisms, but rather the fact of their continuation. Is that right?
Yes, they were considering the costs that had previously been tracked and deferred and the continuation of those trackers.
So the vehicle that those costs are kept, that those costs are tracked. Okay, so if we can please turn to page 25, paragraph 71. In this proceeding, Public Service sought an ROE of 10.2%, which, if you recall the 9.83 that was authorized in the prior rate case, this was an increase from that, correct?
That we were seeking, correct.
And if we can please turn to page 36. Thank you, paragraph 102. We see that based on the weight of evidence, the commission awarded Public Service Company an ROE of 9.3%. Do you see that?
I do.
And that it determined was an appropriate balance between ratepayer and shareholder interests. Do you see that in paragraph 102?
Yes.
And do you accept that there are other balancing factors throughout this decision beyond just the continuation of the deferrals?
I do.
Okay, so we can take this document down. Mr. Berman, do you recall from a moment ago, we talked about the next case in the series that was approved for these
Yes.
deferrals? And do you recall that that was proceeding number 21AL-0317E?
That sounds correct. Yes.
Can we, would you like to check?
No, we can.
Can we please pull from CEC's box hearing exhibit 502? Thank you. Mr. Berman, do you recognize this as decision C220178 in proceeding number 21AL-0317E?
I do.
Again, since you rely on this as evidence of the commission's support for deferral mechanisms, I trust you have some familiarity with it.
I do.
I move the admission of hearing exhibit 502.
Any objection?
No objection.
So moved.
Now, this too involves a rate case in which the commission approved a presented settlement agreement appended to the decision as Appendix A. Is that right?
Yes.
And Public Service Company, again, was a party and signatory to the agreement.
Correct.
And would you prefer to step through the decision and settlement, or do you accept, subject to check, that the settlement agreement reflects a series of negotiated compromises?
I'd accept that.
Such as a reduction to the net base revenue requirement from 342.9 million to 298.8 million.
No reason to doubt that.
Okay, and likewise, a reduction from the requested ROE of 10% to 9.3%.
Sounds correct.
Now, these compromises also allowed for the continuation of the property tax and pension expense trackers, as well as deferrals you referenced for wildfire management and the Advanced Grid Intelligence and Security, or AGIS tracker. Is that right?
I believe the AGIS deferral was originally approved in a CPCN decision. I believe this was a subsequent proceeding where it was reauthorized.
And so those deferrals were decided in this settlement, at which the commission approved, among the negotiated exchange of compromises. Do you accept that?
In this proceeding, I do. Again, some of these deferrals in the past have been approved in standalone proceedings and then reauthorized in rate cases.
And so it's not just the prudence of the investments, again, that are tracked in the trackers, but the continuing fact of these single stream mechanisms. Is that right?
Both the fact of their existence and the costs are approved in these decisions that we've looked at, yes.
Okay. And in the case of the pension and property tax trackers, those were approved for the first time in the context of a rate case as well.
Those two were, yes.
Okay. If we can next please turn to, I believe, page 61 of the PDF. And if we can pull all of paragraph 74 on the screen. And so, Mr. Berman, I'll have you just take a moment and review that paragraph to yourself. And let me know when you've done so.
I have.
As a signatory to this approved settlement, the company continues to stand by its agreement, doesn't it?
It does.
Okay. Now, we can take this document down. Thank you. Unlike the cases we've just stepped through, there is no currently pending public service company rate case, is there?
Today, no, there's not.
And so there's no means to consider the appropriateness of the non-traditional treatment you seek here in the context of the other levers available to the parties or the commission found in a rate case, like the reduction of ROE or rate base, which might help balance the equation, is there?
Well, so again, I don't know that I'd characterize it as non-traditional, and I would again reiterate that companies seeking to track and defer costs. We're not seeking prudence review or recovery of those costs. Those things will be at issue in a rate case. So the commission and other parties will have the same opportunity that they had in all of the proceedings we just walked through to address those issues in a rate case when the company brings them forward for recovery.
But still, even if the prudence of what's decided and what's deferred in an excess liability insurance tracker, if that's saved for a later day, still the fact of the mechanism is being considered here without context of other levers. Is that right?
Correct. It's the request is just to allow the company to track and defer those costs, to have that available to look at in a rate case, which we would not otherwise be able to do.
And when is that rate case being filed?
We don't have a date certain to file a rate case at this time.
Will it be in 2025?
I can't say.
Will it be in
We're
2026?
evaluating it. I mean, if you look at the history of when the company and frequency of the company filing cases, in that time frame would make sense, but we don't have a plan to file at this time, so I can't speculate on when that will be.
And what's the lead time for filing a rate case?
What do you mean by the lead time?
If the company decided, okay, we need to get going on filing a rate case, how long does it take to put all of that together? The strategy, the testimony, the initial filing?
It typically takes 3 to 6 months.
And so even if you decided today, we wouldn't see a rate case until earliest Q2 25, maybe Q3. Is that
That's a
right?
fair assumption, yes.
But you have no plans today.
We do not.
So it would likely be later than that.
I mean, that lead time can vary, of course, based on circumstances and what the company files. So it's possible that we could make a decision and file sooner than that. And it's also quite possible it could be later than that.
Okay. Now, I understand that we may disagree on the likability of regulatory lag. So but do you agree that at least from the ratepayer perspective, regulatory lag can provide an incentive for the utility to efficiently manage its costs?
I think that is the theory behind the use of regulatory lag. And certainly
And
I
we'll get to
think
the company's perspective too. So that's from the ratepayer perspective.
I think that the policy rationale for regulatory lag is what you said. It's to provide an incentive for the company to manage its typical ordinary course of business costs between rate cases but to still give the company an opportunity to earn its allowed return. I think what we're looking at here is something outside of the ordinary.
Okay, noted. But from the company's perspective, regulatory lag may prompt concerns about profitability and creditworthiness. Is that right?
Again, it depends on a number of factors, but as you're well aware, the company has argued for a more current recovery in recent years, and that's very much because of the fact that the company's in an investment cycle continues to be, and that the longer we wait between rate cases, that regulatory lag becomes untenable, and it becomes nearly impossible for the company to actually have a real opportunity to earn its allowed return.
Okay, and so just to distill your answer, is what becomes untenable about regulatory lag concerns about profitability, earning its return, as you noted, and access to capital?
Certainly that's part of it, yes.
So let's shift gears then, and if we can please pull up Hearing Exhibit 101, page 7. And I'll refer you to lines 18 to 22 there. Thank you. Now, Mr. Berman, it's your position that limiting the risk of catastrophic financial events through excess liability insurance coverage, that benefits customers, right?
Correct.
And you'd agree that also benefits shareholders, does it not?
It benefits both, right? It allows the company to mitigate a risk that would impact both sides, yes.
Okay. And so it's your position that both debt and equity investors evaluate the overall risk of their investment. And I'm paraphrasing somewhat here, but because insuring against catastrophic financial events reduces risk, it directly impacts the company's cost of capital to execute its robust capital plan on behalf of customers. Is that right?
Yeah, that's a fair statement.
And so you're familiar, and you just referenced it, you're familiar with the company's robust capital plan, correct?
I am.
And order of magnitude on an Excel-wide basis, does 45 billion projected CapEx for 2025 through 2029 sound accurate?
Yes, it does.
Now, can we please pull Hearing Exhibit 503 from CEC's box? Thank you. Mr. Berman, in making claims about the impacts from excess liability insurance on the company's overall risk and cost of capital, and the company's resulting ability to execute on its robust capital plan, are you at all familiar with Xcel Energy's third quarter 2024 earnings presentation that was made to investors about 3 weeks ago?
Yes, I have reviewed it.
Okay, I move to admit Hearing Exhibit 503.
Any objection?
Maybe just a question. Is this the full presentation? I see 46 pages.
It is, and if you'd like to scroll through to the end, if that would help you, Mr. Mansholt.
No objection.
So moved.
So if we can please turn to page 3 of the presentation. And I'll refer your attention there. We see there at the 4th bullet reference to the Xcel Energy capital plan of 45 billion from 2025 to 2029, with 10+ billion in the pipeline of additional capital investment. Do you see that?
I see that, yes.
And if we can next please turn to page 21. And there we see that currently Public Service Company enjoys a secured credit rating from Moody's of A1. Is that right?
That's correct.
And an A from Standard & Poor's.
Correct.
And an A+ from Fitch.
I see that, yes.
And these are strong credit ratings, are they not?
Yes,
And there's several notches above cause for concern, correct?
I don't know that I could really speak to that. Certainly at any given notch, there will come a change in the cost of capital. So I don't know that I would be able to speculate on where cause for concern is, but if they were to go down at all, there would be a corresponding increase in cost of capital.
Okay, but you do agree that they're strong currently.
I do.
Okay, now I submit to you, and I'm happy to give you a moment to spin through this, but that notwithstanding the company's claims that these excess liability insurance premiums the increases are unprecedented and extraordinary, nowhere does the company mention any risk about under collecting these insurance expenses in this presentation. Do you have reason to disagree with that?
I do not, I'm not aware that this presentation addresses this specific insurance premium anyplace.
And
I haven't reviewed it recently, and I've only reviewed it in an ancillary way, so I don't want to say, but I don't have a reason to dispute that that's the case if we were to go through and review this.
provided just 3 weeks ago in terms of recency.
Right, but I mean, this presentation is a higher level presentation for investors and doesn't typically get into line item detail like we're talking about here for a specific cost to the company.
Now, the wildfire mitigation plan is found on page 41, if we can go there. Do you see that?
I do.
And then the Marshall Fire litigation and potential liability there are mentioned on page 43. Do you see that?
I see this, yes.
But this investor report was presented just days after your insurance renewal and made no mention about the risk of any rising insurance premiums associated with fire events. Is that right?
Again, having not gone through the whole thing, I don't believe it has made a mention of this specific insurance renewal. I do know that the renewal terms and costs were disclosed in our financials for Q3 when just before this investor presentation.
And do you think it's not in the presentation because I believe you referred to it as line item detail, that it's not likely to have much of an impact for investors to worry about?
No, that's not what I referred to. I think that these presentations are prepared pretty well in advance of those discussions, and B, like they cover a very high level for the company, and it doesn't mean that those details are not important or of concern. And in fact, I do believe the company received questions from investors about this issue and discussed it. It was disclosed in our financial statements, but I can't really speak to why it wasn't included in this presentation, as I'm not the one who puts these together and does this investor relations activity.
But you can agree that it's not.
That it's not here?
Yes.
I don't believe it is.
Okay. So let's put a pin in the Marshall Fire and we'll come back to this in a bit. And I'd like to shift gears now. We can take this document down, please. I'd like to shift gears now and discuss the deferrals that you rely on in your testimony in other states. So if we can please turn to hearing exhibit 103, page 24. Lines 14 to 20, please. And so there, Mr. Berman, you point out that other Western state commissions are granting similar mechanisms as requested here. And those commissions include, you name California, Oregon, Idaho, and Washington State. And you point out that no one has responded to these important examples. Do you see that testimony?
I do.
So let's start with the deferrals in California. Mr. Berman, are you aware that California has legislation in place that allows for a wildfire insurance fund and prescribes cost recovery related to wildfires?
I am not aware of all of the details, but I am aware that they have that legislation in place.
So if we can please pull hearing exhibit 504 from CEC's box. And scroll down just so that Mr. Berman can read the top of the Legislative Council Digest. Thanks. Mr. Berman, while I'm not asking for any kind of legal opinion, are you aware that this Assembly Bill 1054 is that California legislation that prescribes a wildfire fund and cost recovery provisions related to wildfires?
I can see that what's here on the screen, and it does appear that this is legislation related to those issues.
Okay. I'll move the admission of this document for the record. And I'll do that now. Move the admission of exhibit 504.
Any objection?
No objection.
Thank you. So moved.
Thank you. Now, do you agree and are you aware that here in Colorado, we don't have any similar related legislation that establishes the rules of engagement about wildfire? Is that right currently?
I would agree with that. No legislation.
And so if you can opine, and this is up to you, but might that affect the California Commission's treatment of wildfire related requests?
I mean, I'd have to refresh me of the timing of some of those requests, but it's a very different regulatory environment in California. The first thing I'd point out is they have always used multi-year plans and future test years. So they're in a very different position when it comes to regulatory lag. And they're in a very different position as it relates to wildfire risk, quite frankly. And so they have a number of tools that are not available in Colorado.
Okay, and so in relying on what's happening in California, you acknowledge that they're in a different spot.
Correct.
Okay, let's next turn to Oregon, and we can take this down, please. You reference in your testimony, and I can cite to it if you'd like, but you reference Pacific Corp's deferral mechanism in Oregon. Do you recall that?
I do.
And if we can next please pull CEC's hearing exhibit 505 from the box. And if we can shrink this just so that Mr. Berman can see the document involved. Thank you. Mr. Berman, you cite to this order in your testimony in this proceeding as an important example. And so I trust that you have some familiarity with this document.
I do.
And do you recognize it as order number 24-021 in proceeding number 2301.
I see the proceeding number, the order number. Yep. Okay. Yes, I do.
Mr. Chair, I move the admission of hearing exhibit 505.
Any objection?
Can we just scroll down fairly quickly? Keep on going to the end, if you don't mind.
Through the whole document. It
Yeah,
says
it's only 7 pages.
And just go to the last page if you don't mind. No objection.
Mr. Chair, is it accepted?
Yeah, sorry, so moved.
Thank you. Now, Mr. Berman, are you aware that Pacific Corp saw the deferral of excess liability insurance premium increases on August 21st, 2023? And we can scroll to page 3 of the PDF if you'd like to check that date.
Great.
There at the bottom.
Yes. Okay.
And are you aware that this deferral, and we can refer please to page 5 of the PDF. And are you aware, if we can scroll down just a bit to the paragraph that reads because is present. Are you aware that this deferral was permitted to occur following a stakeholder process?
I can see that. Yes.
And if we can please scroll to the bottom of page 5 and the top of page 6. Thank you. And are you aware that Pacific Corp faced a $96 million increase in excess liability insurance premiums on a total company basis, spanning its 6-state region, of which Oregon is one?
That appears to be what this says. Yes.
And are you aware that Pacific Corp requested to defer only the Oregon portion of that deferral, of that amount?
I'm not aware of what they did in the other jurisdictions, but I mean, given that this is an Oregon case, they would only be able to seek that relief in the state that they're filing in. So I know that they sought it here.
Are you aware generally that Oregon comprises a percentage of Pacific Corp's system on a system overhead basis?
Yes.
Okay, and so its allocated share would be that percentage. Are you aware?
It would be some percentage. I don't know what the percentage would be, but I agree that it would be some percentage of the total.
And if we can please turn to the bottom of page 7. Thank you. Thanks. Are you aware that the commission granted, and the granting was on page 1, but that the commission granted the deferral of just that amount for a limited time, spanning the 12 months beginning August 21st, 2023? Do you see that? That last sentence there.
I see that it says related to the 12 months beginning. Yes.
Now, unlike in Oregon, there's been no stakeholder process here, has there?
We have not had a stakeholder process related to this request.
And unlike in Oregon, there's no proposed limitation to what amounts might be deferred if the mechanism is permitted. Is that right?
Well, the company has now in rebuttal provided the actual amounts that would be deferred for this policy period.
But the company doesn't request that once those amounts are deferred, the deferral stops there, is it?
No, our request is for an ongoing tracker and to be evaluated in future rate cases.
And that ongoing tracker is not limited as to what can be accruing in that tracker, right?
It's limited only to excess liability insurance premiums.
But the amount is not limited.
The amount is not limited in our request.
And unlike in Oregon, there's no limitation in time or sunset to the deferral mechanism, is there?
Not as proposed by the company, no.
Now, Mr. Berman, are you aware that fewer than 6 months after the deferral commenced, on February 1st, 2024, Pacific Corp filed a rate case in docket UE 433, which is now pending before the Oregon Public Utility Commission, where excess liability insurance costs can be fully considered and included in rate base?
I was not aware of the timing of that case, but I have no reason to dispute what you got.
And unlike in Oregon, as we've discussed, there is no pending rate case here or plans to file one, right?
There's not, and I wouldn't be able to testify whether I don't believe there's anything in this settlement or in this approval where Pacific Corp had stated it would be filing that case. So again, as we talked about, it's possible the company could file a case within 6 months. It's possible it could be a year or more.
Okay, so the company might file a rate case in 6 months.
Again, the company is constantly evaluating the need for these things and with all of the other proceedings that it has in front of it. So there's not a timeline available today that I could speak to.
Now, are you aware that prior to the Oregon deferral application and prior to the rate case filing, on June 9th, 2023, Pacific Corp was found by a jury to be grossly negligent and reckless in association with the Oregon Labor Day fires that occurred in 2020?
I am not familiar with all of the details of that litigation.
Are you aware that there were significant fires in Oregon in 2020
I am.
that resulted in significant litigation that followed?
I am.
And are you aware that Pacific Corp was found liable and found grossly negligent and reckless in association with those fires?
I don't know all the details of what they were found in that litigation, but I have no reason to dispute it if you had a document that showed it.
Are you aware that those fires are a focal point of the pending rate case, including the question of whether ratepayers should be responsible for rising insurance costs that might have resulted from Pacific Corp's grossly negligent and reckless behavior in association with those fires?
I have not looked at their rate case, so I'm not aware of any of those details.
Okay, let's please move on to Idaho. You referenced Pacific Corp's deferral. And if we can please pull hearing exhibit 506 from the box. And Mr. Berman, you also cite to this order in your testimony in case number PAC-E-23-18, order number 36045. Do you recognize this as the Idaho deferral to which you referred?
Yes, it appears to be.
And so I trust in referencing it that you at least have a working familiarity with this document.
Yes.
I move the admission of exhibit 506.
So moved.
Are you aware, Mr. Berman, that Pacific Corp seeks to defer Idaho's share of its total company excess liability premiums in excess of that collected through base rates?
Yes.
And that Idaho's share would be some percentage, like Oregon's, some percentage of the total. Is that right?
Correct. Yep, I agree.
And if we can please scroll to the top of page 5. To that first, it is hereby ordered. And do you see there that the deferral approved by the Idaho Commission is limited in duration to the earlier of the company's next general rate case or December 31st, 2026?
I do see that.
And unlike in Idaho, this proceeding, there's no limitation in time or scope to the company's deferral, is there?
Well, I mean, one of the things that this says is to the next general rate case, and what I'd point out is all of these issues and trackers are always litigated in rate cases. So certainly that would be a time that it would be back up for discussion.
Okay. But the company's not proposed that as part of its application, has it?
Not proposed when we would file a case, or that it would be,
That it would be considered for renewal at that time. The company is asking for an ongoing tracker.
well, I guess I would say from, in my experience, those trackers are always litigated in every rate case. So I personally would not feel the need to put that in testimony. I think it is a given that this would certainly need to be reauthorized in every subsequent rate case.
So in requesting an ongoing tracker, you think it's a given that the company would be amenable to that ending at the next rate case?
I
Or
think it
sunsetting
is.
at that time?
I think that it will be a decision of the commission in the next rate case and in every rate case, whether to renew all of the company's trackers. It always is with all of the ones we've spoken about today.
Okay, let's move on to Washington. You mentioned a pending deferral in Washington. Are you referring to a Pacific Corp request? You didn't give any docket with that. There's a Pacific Corp request for a deferral in docket UE 230673. Does that sound familiar?
Could you point me back to the testimony that we didn't? Yeah.
Sure. If we can pull hearing exhibit 103. And then just while we're getting that, for the commission's benefit, I think I am going to need those remaining 15 minutes, but I think I can keep it to that.
Okay.
Thank you. There you reference, thank you, Ms. Kunkel, there you reference a similar request is pending in Washington State. Do you see that?
I do. And I can't remember if there's discussion specifically of it in a later part of the testimony. I thought there might be a reference, but it sounds familiar that it would be Pacific Core as these others are.
Okay, and so if we can please pull no, okay, never mind. Do you, to your knowledge, has the Washington Utilities and Transportation Commission taken action in that case?
No, we recently checked and it's still pending.
Okay, so while you don't mention it among your list of other jurisdictions, are you aware that Pacific Corp also operates in Wyoming?
I am.
And in its 2023 rate case, are you aware that Pacific Corp was permitted to seek a limited deferral for incremental excess liability insurance expenses, but ultimately filed a 2024 rate case to consider those among all the issues in the rate case?
I've not looked at those issues specifically in Wyoming.
Okay, are you aware that Pacific Corp also operates in Utah?
Yes.
And are you aware that Pacific Corp sought a deferral in Utah in docket number 23-035-40?
I'm not familiar with that specific docket.
But are you aware that Pacific Corp sought a deferral of its increased premiums for excess liability insurance?
I generally am, yes.
And are you aware generally that the Utah Commission denied that request on the basis that the unprecedented increase may, to some significant degree, be tied to the conduct of Pacific Corp in being grossly negligent and reckless in association with the Oregon fires?
I am aware that it was denied. I have not gone through the order of the details. I am also aware that the facts and circumstances are different in all of these proceedings, certainly from ours as well.
And so while you refer to them as important examples, they're a little bit different. Is that right?
I think, yeah, all of them are going to be their own sets of facts and circumstances. And the important thing here that I was referencing is just some of the actions other commissions have taken in states like California, Oregon, and Washington that have seen some of these risks come to their doorstep sooner than Colorado. And as evidence that these are the types of things we should be considering here.
Now, California, we talked about, has a statute in place that you said makes it different. Now,
Well-
Oregon has, is that right? You said
They
that.
are all different, but the overarching point is that there are, whether it be legislation, whether it be commission activity, there have been actions in all of these states to assist utilities with these risks or to support the risk mitigation that utilities are undertaking. And so that's kind of what I'm likening the situation here in Colorado to now.
And so in Oregon, Utah, Wyoming, there are pending rate cases where those issues are going to be considered. Is that right?
As we've walked through, it sounds like there are pending rate cases that consider those issues. Correct.
And just for the sake of the record, are you aware that there is a pending rate case in Utah where this question about the deferral has been consolidated so as to protect ratepayers from paying unnecessary costs? Are you aware of that?
I was not aware of the consolidation in
Okay.
the rate case in Utah.
Now, picking up where we left off on the Marshall Fire, if we can please pull back up Exhibit 503 and turn please to page 43. Now, I'll refer your attention, Mr. Berman, to the second and also the final bullet points that are shown here. Do you see those?
I do.
And now, although the company disputes any liability associated with the Marshall Fire, the verdict has not been issued in that case, correct?
That's correct.
And we won't have a verdict on liability until at least September 25, based on this presentation. Is that right?
This presentation states that is when the trial will begin, tentatively.
And if there is a verdict of any liability on Public Service Company's part, we won't know the extent of the damages until sometime after that. Is that right?
That's correct.
And that fire occurred on December 30th, 2021. Is that right?
That is correct.
And the unprecedented jump in insurance premiums occurred since then, right?
We have, I mean, we laid out in testimony the history of the changes in the insurance premiums, which had been rising, but yes, the policy that was just signed in October is the policy at issue here with the very large increase.
So the very large increase happened after the Marshall Fire, just to be clear.
It did.
Okay. And so we don't know, as we sit here today, whether or to what extent the increase in premiums is attributable to any liability associated with the Marshall Fire. We just don't know, right?
Certainly the insurance companies have not told us anything about how that's impacting their decisions on premiums.
And we won't know for some time, right?
Well, we won't have a decision in the Marshall trial until after September of 25, as we discussed.
Okay. Thank you, Mr. Berman. I have no further questions.
Thank you, Ms. King. Mr. Smith. 30 minutes.
And Your Honor, it will be Justin Larson who will be conducting our cross. Thank you.
Mr. Larson, welcome. Welcome to the process.
Thank you, Mr. Chair. Good morning, Mr. Berman. I don't believe we've met yet. My name is Justin Larson. I work for the Attorney General's office, represent trial staff in this proceeding. Nice to meet you.
Good morning, Mr. Larson. Nice to meet you.
So I'm just going to start off with some general questions about liability insurance costs and the nature of this proceeding. These questions might seem a little bit basic, but I think it'll be helpful to set the stage for some of the more specific stuff. So please just bear with me, all right?
Okay.
Okay, so starting with the cost item at issue in this case, the cost of liability insurance premiums is generally what we would call an operation and maintenance cost, or O&M costs, right?
That's correct.
And it's fair to say that O&M cost is really an umbrella term that encompasses a lot of different subcategories of costs. Is that right?
Yeah.
Generally speaking, O&M costs are an element of costs included in base rates approved in a general rate case.
That's true.
And these base rates are generally set on the assumption that costs included in the base rate calculation are relatively consistent over time. Is that fair?
I would agree with that.
So embedding volatile costs in base rates that might change significantly from year to year will lead to either over or under recovery of that cost.
That's correct.
Now, generally speaking, the company bears the risk of incurring excess costs beyond those that are approved in base rates. Is that fair?
Yes, that's fair.
And conversely, ratepayers bear the risk of paying for costs approved in base rates that are not actually incurred by the company.
Correct.
So would it be fair to say then that the company has a strong incentive to correctly estimate what these costs will be when it seeks approval of its base rates?
That would certainly, yes, but I mean, just to be clear, like the typical rate making mechanism has been historic test years, which would utilize historic costs, not a company estimate.
Right. I appreciate that. Thank you. So similarly, and I believe you talked about this a little bit with Ms. King, it's generally in the interest of both the company and the ratepayers that the company do what it can to control these costs between rate cases.
Agree. Yes.
Now, turning to the nature of this proceeding, a deferral and tracking mechanism like what the company is asking for here can be appropriate to ensure that utilities are not on the hook for excess costs incurred between rate cases that are beyond the utilities' control. Is that fair?
That's fair, and it can go both directions, right? If we have a tracking mechanism, it could also pick up any savings for customers if the cost reduces, given its volatility.
Thank you for that. And are you aware of any examples you could give where that's the case, where the customers were refunded for over collected costs?
I do believe that we've had examples in the property tax deferral where we've utilized like a known and measurable adjustment from a historic test year to estimate the next year's property taxes, and they haven't come in quite that high. And so those credits have been put into the deferral. I think there are also examples on the gas side of the business with emergency response and damage prevention trackers where we've seen both debits and credits in the deferral. So, the intent of those is really to make sure that customers are only paying the costs the company actually incurs.
And so looking to the other side of it, where the company incurs excess costs, without approval for tracking and deferral, the company has no way of recovering those excess costs incurred between rate cases. Is that right?
That's correct.
So wouldn't it be fair to say that tracking and deferring excess costs carries with it a presumption that the company will ultimately seek to recover those costs?
Certainly, if the company tracks and defers the cost, we will, outside of somehow the company determining that they were not prudently incurred, we will bring them forward and seek recovery and a prudence determination in a future proceeding. Yes.
And can you recall an instance in which the company has requested tracking and deferral without actually ultimately seeking recovery?
No, I can't.
Now, as a general principle, wouldn't you agree that, and again, this is not talking about anything specific, just general principles here. Wouldn't you agree that it would be unfair for ratepayers to pay the cost of the company's mistakes?
I mean, I think if you're saying mistakes, I would say that generally that would mean the company acted in an imprudent way somehow.
So that's a yes.
If that's what we're talking about, yeah, the cost recovery is predicated on prudent activity by the company.
So isn't it fair to say then that a deferral and tracking mechanism is really only appropriate for cost increases between rate cases that are unforeseeable and beyond the company's control?
I think there's a number of aspects that you would review in looking at those. I mean, we talked about how when we set that O&M level, that it should be representative of normal activity. And so when we talk about things that are generally outside of the company's control, that can be very volatile, that are changing one direction or the other materially in between cases, I think that is exactly the use of these deferral and tracking mechanisms in between rate cases, particularly when we're utilizing historic test years to set base rates.
I appreciate that, Mr. Berman, but I'm not sure that really answered my question. So generally speaking, would you agree that deferral and tracking is appropriate in cases where the cost increases beyond the company's control or not able to be foreseen by the company when it set its base rates.
I think that is one rationale for it, yes.
And of course, that's what the company is claiming in this case. Isn't that right?
Yes, we did not see this change when we filed our last rate cases.
Now, turning to the cost increase at issue here, the company has cited a number of different potential causes for the increase in its insurance premiums. Isn't that right?
Yes.
And these include things like climate risk, wildfires, and wildfire-related litigation.
Certainly wildfire risk, I'm not sure about. I mean, you have to point me to climate risk if that was cited, and that's certainly one of the things driving wildfire risk. I know that was something staff evaluated.
And Mr. Berman, in the company's view, these increased costs are extraordinary, right? Or outside the norm?
Yes, as we look at these insurance premiums, the renewal here is significantly more than we've seen in any historic year.
Now, wouldn't it be fair to say that increases in wildfire-related risk is not something particularly new to the company?
Well, it's not new. I guess it depends on what you want to say about new. I think that it's evolving in a rapid way, and so it's become very clear that even from the company's last wildfire mitigation plan to the one that's pending in front of the commission now, there's been substantial change, hence the differences in those plans of scope and scale and risk.
Now, you mentioned in your direct testimony, and I believe in discussion with Ms. King a little as well, that the company currently has its wildfire mitigation plan application proceeding pending before the commission.
Correct.
And in fact, that proceeding was preceded by an earlier wildfire mitigation plan proceeding that was initiated in 2020. Isn't that right?
That's right.
And wouldn't you also agree that these increases in wildfire-related risks are not necessarily expected to decline in the coming years?
I mean, I don't know that I would. It's a challenging question, right? I mean, there's obviously a lot of proposed risk mitigations in our wildfire plan. So to the extent that we execute on all of those mitigations, I would expect reduction in risk. But again, at the same time, the landscape of those risks is changing so rapidly that, we don't know what that's going to look like 3 or 4 years from now.
So that being the case, wouldn't it be fair to say that what the company considers extraordinary today might become ordinary in the near future?
Certainly if a trend evolves, it could be looked at as more ordinary in the future. I don't know what the future would hold.
But in this case, the company isn't really taking a position as to what the commission's policy should be going forward on increase or volatile insurance premium costs.
No, we're simply acknowledging that they are volatile today and that they are a significant change today and asking to track and defer that for future evaluation.
Now, you did mention in your rebuttal testimony that the company is not seeking to avoid regulatory lag through a strategy that uses rider recovery to recover excess liability insurance premiums. Isn't that right?
That's right.
So just to be clear for the record, if the commission were to grant the company's request in this proceeding, the company is committing to not seeking rider recovery for these deferred costs, and instead it will only bring them in a future rate case.
I don't believe we've taken a position on that, but we're not asking for a rider for these costs now. We're asking for deferral, and so they would need to come forward in a cost recovery proceeding. Whether that be a rider, I don't know that we would foreclose that, but I do think a rate case is the most logical and likely scenario for where these would come forward.
So the company is not willing to make a commitment to not seek rider recovery in the future?
I mean,
that's mischaracterizing the witness's testimony.
Objection overruled. I think that's a legitimate question. If you want to state it again, Mr. Larson.
Thank you, Mr. Chair. Mr. Berman, is the company willing to make a commitment today to not seek rider recovery for these deferred costs if the commission were to grant its request today?
We have no plans to seek these recovery of these costs in a rider. I don't believe there's a rider today where it would make any sense. And certainly if the commission wanted to grant this request with a provision that they had to come forward in a rate case, the company would understand that and would not object to it. But we're not agreeing to not bring it forward in this particular proceeding today.
Thank you for that. So I just want to close with a little bit more detail about the liability insurance costs in this case. The company has stated that numerous factors that insurers consider in setting premium prices, some of them are market-based and others are specific to the individual customers. And is that fair to say?
That's fair.
And the company can't say precisely the extent to which the increases we've seen in this case are due to its own specific liability factors or overall market factors. Is that fair?
I'm going to say generally fair, but Mr. Miller is the witness who actually speaks to the insurance company, so he would know better than I, but that's my understanding, yes.
Can we please bring up what has been pre-marked in staff's boxes, hearing exhibit 401? Thank you. Mr. Berman, do you recognize this response to one of staff's recovery requests in this case?
I recognize it, yes. I would need to be refreshed with the full document if we want to talk about the responses.
And you were one of the sponsors of this response, correct?
Correct.
Mr. Chair, staff moves to admit exhibit 401.
Any objections?
No objection.
So moved.
Okay, so I'm going to direct your attention, Mr. Berman, to the response to CPUC 1-6 subsection B. It's going to be down there under the responses. And if you could just read along with me as I read aloud, quote, admit that instances of wildfires, consequent litigation, and ongoing risks of climate change are contributors to the increase in the excess liability insurance premiums, end quote. Did I read that correctly?
You did.
So despite not necessarily knowing what impact the company's specific litigation risks have had, the company does acknowledge that it has played at least some role in the increase in insurance premiums. Is that fair?
Yes, I mean, certainly it'll play a larger fact in future negotiations for these premiums after there is an actual decision in litigation.
Right, but wouldn't you agree that that litigation claims, even before they're adjudicated, can plausibly have a bearing on an insurance premium?
I think it could plausibly have a bearing. I couldn't say to what degree.
Now, without getting into any of the specifics of any current litigation, just purely hypothetically speaking, if the company were to be found liable for damages for something that occurred within its service territory, wouldn't it be unfair for ratepayers to bear the cost related to that liability?
I think it would depend on the facts and circumstances. I mean, we've talked about different things. I think Ms. King talked about Pacificor and a negligence finding. Now, a negligence finding, yes, would seem that the company acted imprudently. But simply liability, I don't know that would preclude if the company operated its system appropriately and still was liable for some issue. I don't know that that's definitely saying that it was imprudent.
So just to be clear, let's just add negligence to the hypothetical. So the company is found liable for negligent acts which lead to damages in the context of with something that happened in its service territory. The ratepayers, in your view, should not have to bear the cost of that liability. Is that fair?
Objection. That instance is not at issue in this case. It's outside the request of this case. It lacks relevance, and it's asked the witness to speculate on an event that's not an occurrence.
Would you re-ask the question maybe in broken up pieces so we can deal piece by piece?
Absolutely, Mr. Chair. So if Mr. Berman, hypothetically speaking, if the company were to be found liable for negligent actions which lead to damages in its service territory, in your view, should the ratepayers have to bear the cost of that negligence?
Objection, or renew the exact same objections, lacks relevance, asks the witness to speculate, involves issues that are all outside of the request of the company in this proceeding.
Overruled. I think he can answer.
I think it's highly dependent on issue by issue. I mean, I find it kind of impossible to speculate on what those circumstances would be. I don't know of any instances in the past where the company was found negligent, where we sought recovery of costs related to that from ratepayers.
Thank you for taking the time, Mr. Berman. Mr. Chair, staff has no further questions for the witness at this time.
Thank you. Ms. Crampton, and just so you know, we're gonna take a break from 10:45 to 11. So apologies for that, but just wanted to give you a heads up, so hopefully you can manage to that as best as possible.
No worries, and thank you. Many of my questions have already been asked, so hopefully this won't take as long as anticipated. Good morning, Mr. Berman.
Good morning, Ms. Crampton.
We have met before as well, but just for the record, I'm Kate Crampton. I'm one of the attorneys representing the UCA. I'm sorry, I'm a little dark on the screen here.
No problem.
I wanted to follow up just with some questions about the out-of-state cases that you and Ms. King had a discussion about. If we could pull up CEC's hearing exhibit 506, which is the Idaho Commission decision. And if we could scroll down, sorry, my format on my copy is a little bit different. So if we could go down to the staff comments section. And just, if we could scroll down just to that paragraph that says, starts with despite. Okay. And Mr. Berman, here the commission staff for the Idaho Commission raised the concern that it was only appropriate to book the insurance costs for actually incurred premium costs into the regulatory asset. Is that right?
Where is that?
Just where the cursor is, that last sentence of that paragraph, that staff opined is not currently appropriate to book insurance costs other than premiums actually incurred as a regulatory asset.
Yeah, that I see that, and the company's not proposing to book anything that's not actually incurred.
Okay. Well, and put differently, the staff in Idaho thought that the actual amounts of the insurance premium mattered to the decision on whether to grant the deferred accounting.
I mean, all I can say is what it says here, that they should only book costs that were actually incurred, which would be standard accounting process.
Okay, and the decision here for the commission was whether to grant a regulatory asset for deferred accounting.
I believe that's correct.
Okay. And you would agree that this is different than the position you took in this proceeding where you testified, and I'm sorry, if we could pull up hearing exhibit 103. And I believe page 10. And just lines 19 to 21. I'm sorry, page 11, my apologies. And this, Mr. Berman, this position of the Idaho staff, you would agree is different than the position you've taken here, which is that knowing the exact amount of the potential, that you disagree that knowing the amount of the potential deferral is necessary for the approval of the deferred accounting. Is that right?
I don't know if that's correct. I mean, I have to go back. I'm not sure what the Idaho staff's position was there. The position here is that the company provided an estimate and sought the approval of the regulatory asset to open it. What I read in that other decision was that they wouldn't book anything other than what was actually incurred. And the company is not proposing to do that. To be clear, the company was providing at the time that we filed this, what our estimate was. We now know what the actual premium cost is. But the point I'm making here is that the exact dollar amount is not necessarily relevant on the decision to open the deferral, because all you're doing is tracking, and all of those costs are going to be brought forward in front of the commission at a future proceeding in order to review them. And we're only going to bring forward actually incurred costs.
Okay, I think I understand. And when you say the amount is known here, you would agree that the company now has an estimate, but the final allocations won't be known until April of 2025. Is that right?
Correct. The actual final allocation will change, I would guess, in an immaterial way.
Okay. And if we could go back to that hearing exhibit 506, please. And just scroll down to the next paragraph that's next page, actually, the bottom of that first paragraph. And Ms. King had asked you questions about the time limitation that was placed on the deferred account in Idaho as being limited to either the company's next general rate case or December 31st, 2026. Is that right? Do you recall that discussion?
I do.
And that provision in the Idaho order was consistent with the recommendation of the Idaho trial staff. Is that right?
Yes, that seems correct.
Okay. And the rationale that staff provided in Idaho contained here in this order is that staff believed the deferral period should be limited to avoid rate pancaking. Is that right?
I don't know if I see pancaking. Oh, there it is. Yep. Okay. I see that. Yes.
Okay. And so their essentially trial staff shared the concerns of the interveners in this proceeding about an open-ended deferral account and the impact that could have on consumers, correct?
Well, no party to this proceeding has recommended limitation like this. Certainly the company could have responded to that in rebuttal had a party suggested a time limit to the deferral.
If we could turn to your rebuttal testimony, hearing exhibit 103. And if we could go to page 8. And if we could just scroll down. That's good. Thank you. And Mr. Berman, here is where you summarize CEC's position or concerns in this proceeding that they raised in response to a discovery question. Is that right?
Correct.
Okay, and what CEC had indicated in discovery and what you noted in your testimony is that one of their concerns was the lack of a sunset of the deferral. Is that right?
Yes, they indicated that generally. They didn't provide any answer testimony with any specifics.
Okay, but they raised that concern as an intervener to this proceeding.
One of many concerns they had, yes.
Okay, thank you. If we could now pull up the Oregon order, which is hearing exhibit 505. And again, the format I have is a little bit different, so I'm going to do my best to get the right page numbers. And one of the things that's noteworthy about this Oregon decision is that in this proceeding, the trial staff of Oregon actually made the recommendation to the commission to approve the deferral request, correct?
Yes.
Okay. And here, none of the interveners to this proceeding have made the recommendation that the commission approve the company's request.
Agree.
And in Oregon, and if we could scroll to, I believe it's page 2 of this decision. And I'm sorry, I think it would be the next page. That's page 3. Okay, yes, thank you. And here, Mr. Berman, the Oregon Commission has set forth requirements for what must be contained within an application for deferred accounting, correct?
Yes, correct.
Okay. And specifically, what this order notes is that, and just directing your attention to that second paragraph starting with amounts, that amounts deferred are allowed in rates only to the extent authorized by the commission in a proceeding under the Oregon provision to change rates and upon a prudence review. Is that right?
Yes, that would be referring to when recovery of that would be permitted.
Okay, that's your understanding. And this, of course, is not a prudence proceeding or prudence review proceeding.
It is not, no.
Okay. And what the order goes on to discuss is the last general rate case, docket UE 399 and order 22491. And you've had a chance to review this portion of this order prior to today, right? You've
It's
seen
been a
this
little while, but yes.
Okay. And what this order indicates is that in that order 22491, there was a stipulation to not request deferral of costs or revenues unless one of 5 scenarios were occurring. Is that correct?
That appears to be what this says, yes.
Okay. And those are set forth in this paragraph of the Oregon decision.
Correct.
Okay. And in this scenario, trial staff to Oregon did not find the first 4 provisions, A, B, C, or D, had been met in order to make the recommendation for deferred accounting. Is that right?
I would have to review the analysis that is that what it says below?
Yes, if we could just scroll through the analysis and let me know when you've had a chance to refresh your recollection.
We could keep scrolling. And just a little more.
And if we could,
Yep, I'm good now.
okay, and if we could just scroll down, I think, to the next page. And what the analysis was of staff, it was that a deferral was necessary in this particular circumstance due to component E, which was necessarily to respond to a material threat to the financial stability of the company. Is that right?
In this case, yes. I mean, these are all prescribed things that are different in this jurisdiction from Colorado, but yes.
Sure. You would agree that in Colorado, we don't have sort of the same level of protocols to determine when this deferred accounting may be appropriate as it appears Oregon does from this order.
Correct.
Okay. But the Oregon staff made that recommendation based on a finding of component E. And that was because Pacific Core's Moody's rating metric had gone from an A3 to a Baa1, correct?
I see that, yes.
Okay, and that's in that second paragraph there.
Yes.
Okay. And as you walked through with Ms. King, public service doesn't have that same Moody's rating concern. Public services Moody's rating is currently an A1, correct?
It currently is an A1, that's correct.
Okay. And if we could scroll down just a little bit, and I think you've kind of touched on this, but the facts in Oregon and specifically that exception found in provision E, you would agree that those are facts specific to the circumstances in Oregon?
I would, yes.
Okay. And in fact, in the order issued in Oregon, the order contained language that indicated that staff proposed that the parties agree that the commission decision in this docket would not be cited to or pointed to in any future deferral request.
Objection. Could you please restate that question?
Sure. Mr. Berman, you would agree that in this Oregon order, there is language that staff to the Oregon Commission and the parties agree that the decision in this docket would not be cited to or pointed to in any future deferral request. Is that right?
Could you point me to it? That sounds like standard language in these types of documents, but
sure. Just looking at that paragraph up on the screen, towards the bottom, there's a sentence that begins to attempt to resolve this issue, comma. Do you see that?
Yes. Yes, okay, I see that.
And so this order from Oregon contains that language.
It does.
Okay. And the reasoning, perhaps, is, as you've said, because the facts in Oregon were unique to Oregon.
Sure, I would agree with that too.
Thank you. I don't need that exhibit up anymore.
I think maybe if now's a good time, maybe we'll take a break till 11. Would that work for you, Ms. Crampton?
Yes, that'll work. Thank you.
Does that work for my colleagues, Commissioner Plant? Commissioner Gellman.
Yes.
All right, let's take a break till 11. You're up, Ms. Crampton.
Thank you. Hello again, Mr. Berman.
Hello.
Mr. Berman, in your direct testimony, sticking on the topic of other jurisdictions, you cited the example of California and the California's Commission's authorization for Southern California Edison to record and track, quote, certain costs related to wildfire insurance coverage and claims. Is that right?
That sounds correct.
Okay. And those certain costs, some of them involved the insurance premiums. Is that right?
I don't remember the very specifics. If we had the order, we could look at it, but was really just pointing to the fact that there was an authorization for cost deferral there.
Okay. And that proceeding that you cited to in California, that was a 2018 case. Is that right?
Sounds correct.
Okay. And so at least since 2018, other Western states have been dealing with insurance premium issues related to wildfire. Is that right? Okay. And Ms. King had discussed with you the creation of the California Wildfire Fund, and I believe entered that authorizing statute into evidence. Do you recall that discussion with her?
I do.
Okay. And that legislation in California, that occurred the very next year, 2019. Is that right?
Correct.
Okay. So since at least 2019, Western states like California have been dealing with the issue of how to address wildfire costs and for damages from wildfires.
Agree with that. Correct.
And in the application filed by the company in this proceeding, you cited to the website for information about the California Wildfire Fund. Is that right?
Which website? The actual fund administration site?
Yes, and if it's helpful, if we could pull up hearing exhibit 100 and page 4. And if we could scroll down to footnote 3.
Yes, I see that.
Okay.
Yep.
And that was where you cited to information from the California Wildfire Fund. Is that right?
Correct.
Okay. And I assume because you cited it in the company's application, this proceeding, you've had a chance to go to that website and familiarize yourself with it, correct?
Yeah, it's been a little while, but yes.
Okay. If we could pull up from UCA's box hearing exhibit 304. Okay, and Mr. Berman, I would offer to you that this is a screenshot of that website, the California Wildfire Fund, and specifically the page regarding participating utility companies. Do you recognize this from your review of that website?
Yes, this looks familiar.
Okay. And what is true is that since the creation of the California Wildfire Fund, that Southern California Edison is in fact a participating utility in that fund.
Could you make this a little bigger? But yeah, I think correct.
Okay. And I apologize. I would move to admit hearing exhibit 304.
Any objection?
No objection.
So moved.
And we can take that down. Thank you. Mr. Berman, excess liability insurance is provided at the Excel enterprise-wide level. Is that right?
Yes, that's correct.
Okay. And then once it is obtained, certain amounts are allocated to each of the subsidiary companies, such as public service, correct?
So the policies do have direct assigned portions that the insurers provide to each operating company, as well as an overarching portion that gets allocated.
Okay, thank you. In your testimony, you did not cite to any examples of any other Excel subsidiaries where they have been granted deferred accounting treatment for their excess liability insurance expenses, correct?
That's correct.
I think you talked some about this with both Ms. King and Counsel for Staff, but in your testimony, you claim that the excess liability insurance provides a benefit to the company's customers. Is that right?
Correct.
And in answer testimony, UCA witness Mr. Fernandez disagreed with this notion that excess liability insurance only benefits ratepayers. Is that right?
I believe that's correct.
Okay. And in fact, Mr. Fernandez noted that in the company's last gas rate case, company witness Mr. Johnson testified that the credit rating agencies and the company's shareholders are very concerned about wildfire liability.
That sounds like an accurate statement from what Mr. Fernandez said, yes.
Okay. And in fact, wildfire liability conversations are part of the presentation that was given to investors back on October 31st of this year.
Correct.
To the extent that credit agencies and the company's shareholders are very concerned about wildfire liability, the presence of excess liability insurance premiums in the event of a catastrophic event will assuage those concerns, correct?
I think to a degree, right? I mean, it covers up to a certain amount, and the concern is a general concern that wildfire for liability and other reasons is changing the risk profile for utilities.
Okay. And in this scenario, the risk to shareholders and debt holders can be mitigated by the presence of excess liability insurance.
It can be partially mitigated, yes.
Would you agree that for regulated utilities like public service, the authorized rate of return is based in part on the risk of the company?
I would agree.
And in fact, in answer testimonies, both UCA and staff witnesses raised this issue of the relationship between the costs associated with wildfire risk and the key rate case matters, like what is the appropriate authorized ROE?
Yes, I agree with that as well.
And you would agree that in this proceeding, as presented by the company in its application, the commission doesn't have any mechanism to reconsider any previously authorized ROE.
And that's why the company's not asking for cost recovery or prudence in this proceeding. So the commission will have that lever available when those issues come forward in a rate case.
Okay, so the prudence consideration the company requests occur after the authorization for this tracking and deferral.
Correct.
And essentially, in answer testimonies, staff and UCA disagree with that chain of events proposed by the company. And in their opinion, these issues should be considered as part of a rate case, correct?
Yes, that seems accurate of their positions to me.
Okay. And would you agree that if the company does file a rate case, it could capture these increased excess liability expenses in the test year?
It could be captured from an ongoing basis, but the costs the company's going to incur from this policy would not be recoverable unless we can track and defer and bring it forward for evaluation in the next case.
And you have testified here today that you don't know when the next rate case will be filed.
That's correct.
If we could pull up from UCA's box, hearing exhibit 306, please. And if we could just scroll down. And Mr. Berman, you are the sponsor of this response by the company to UCA 2-1, is that right?
I am, yes.
I would move to admit hearing exhibit 306.
Any objection?
None.
So moved.
Okay. And Mr. Berman, the cost of excess liability insurance is one factor that could contribute to the company filing its next electric rate case, correct?
Agree.
I don't have any further questions.
Thank you, Ms. Crampton. Commissioner Plant.
It's just really. Hi, Mr. Berman.
Good morning.
I just had a couple of quick questions. Is there any way for the company to waive the relative risk that it experiences in the various?
Commissioner Plant, I think you have some feedback.
Okay, never mind. I'll wait my questions.
Yeah.
Commissioner Gelman, you sure, Commissioner Plant? You want to come back, or Commissioner Gelman?
I don't have any questions. Thank you.
I have a couple questions for you, Mr. Berman. Can you help me better understand why this deferral request couldn't have been put forward in the next rate case? Why does this have to be decided now on what seems to be a bit of a rush time frame and a partial record, since we don't know the duration of the tracker and thus the dollar amounts?
Yeah, so the way this works, and I think there was some discussion of this with Ms. Crampton just briefly, right, is like when we use a historic test year to set rates, we're setting a level of O&M that the company expects it can manage within a normal course of business between rate cases. When we have a cost like this that comes up, and we now know the cost of this pushing up against $50 million for the term period we just signed, if we put it in our next rate case, we could embed a level of expense in rates going forward, but we'll never be able to come back and pick up the in-between rate case piece. And so from my perspective, right, when we think about regulatory lag, it makes sense for the company to manage issues that it can manage, but this is one where we feel is largely out of our control, has been very volatile, happened quickly and emergent. And without this tracking and deferral, there'll be no mechanism to pick up the cost the company will actually incur related to this policy and anything else in between cases, right? We wouldn't be able to embed any of that in rates until the next rate effective date.
But couldn't you, at the time of the next rate case, ask for a recovery of this sort of an extraordinary expense?
I mean, I think I would certainly expect some retroactive recovery arguments if we were to do that. And so I think these things are cleaner if you can track and defer them and then bring them forward for evaluation in the case, and consistent with how we've treated some of these things, these types of expenses in the past. I think creates a record, at least from the company's perspective, that is a lot stronger to work with in that case than for me to file a case in 2 years and reach back and try to grab O&M costs we experienced in between cases.
Well, can you help me understand why this case was filed in December before you had a final insurance policy? It seems like this maybe premature filing forced the parties to submit discovery and answer testimony without being able to have a view of the final policy. And more specifically, what's the urgency that requires an end of year decision through an en banc hearing at a time when the commissioners are otherwise pretty jammed up?
So the timing of the filing, we really tried to time it with when we felt we had good information to estimate what the cost would be, which I think Mr. Miller could talk about, but those negotiations with the insurance companies, as we talked about, went even past the renewal date. However, we did land very close to the estimate. So I think we filed it when we thought we had the best information to file it and give an accurate estimate of what we expected to incur, knowing that we would be able to update that to the actual during the course of this proceeding. As far as the end of year decision, that's really an accounting based rationale. Without having a decision by the end of the year, we would not be able to defer anything for 25. Now, if the commission, certainly the commission could decide this later and the company and authorize the company to start deferral from the time of renewal, and then we could pick that up. But for purposes of closing our books and records for calendar year 24, our preference obviously would be that we would have a decision here so that we would know how to treat these costs for those financial statements and accurately portray them.
So there's no external driver between an end of year for an end of year decision. It sounds like for accounting convenience, we're now jammed up in an en banc hearing. Is that sort of what's going on here?
I think we thought that this was a pretty narrow issue that could be expedited, and B, it is important to the company to account for these things correctly. And if we're going to land there, stating our financial statements for 24 as accurately as we can is important to the company. So that is the case. But again, if the commission were to authorize a deferral from a date certain in the past, we could still defer those costs.
And we could have done that in March of 2025 or through a more normal ALJ process that didn't jam the parties and the commissioners.
We could have done that. I do think the financial statement accuracy was important to the company.
And I forget which state, whether it was Oregon or Idaho, but it sounds like one of the other states had a stakeholder process. It sounds like you did not do that here.
I think those states have very different guidelines for how to treat these things. I think we saw like that list in one of those decisions, and we don't have rules or guidelines for how these deferrals come forward in Colorado. And so I'd be careful like comparing it to that in terms of the company not wanting to have a stakeholder process. I think we don't necessarily have the definition around process that some of those states have.
I know, but I mean, you just it seems to me maybe you could have resolved some of these differences without having a fully litigated case before an en banc commission. Let me ask you this. If we issued an order in this case that says something like, yes, these insurance costs are a somewhat unexpected expense that exceeds the amount in existing rates, but did not enter any accounting order and left everything else to the next rate case, why would that be a problem? So then you can make whatever, it would flag the issue. It would say it was unexpected and significantly greater than what's in rates now. And then we could just take everything else up in the next rate case.
Again, I think the company would expect to run into some retroactive rate making arguments from other parties. I think for the commission to approve the order and allow the tracking and deferral does not carry with it any prudence judgment or recovery judgment. So I think if the commission authorizes that, you all still retain full ability to address all of this in a rate case going forward. And it gives the company the flexibility to deal with those costs and not have them impact our financials in that way today until we have a decision on them in the future.
What happens if we just set an order saying that company on this issue can make can ask for retroactive rate making? So we took that issue off the table, but then, set an accounting order in place with unquantified dollars.
Well, I think one option at your disposal is to quantify dollars. I think that we would
But
certainly.
that's not what you're asking for.
I'm sorry?
That's not what you're asking for.
We're asking for a tracker, but I think it's within the commission's purview to think about how you want to set that tracker up. And if parties had have suggested it be for just 1 year or for some set amount, like certainly the company could have engaged with that discussion and rebuttal. But without the tracker, it will impact the company's financials up until the point that we get a decision on these costs in the future. Hanging them up allows us to pull it off and set it aside for that discussion in the next rate case.
As I understand it, this insurance cost is an O&M expense that in the normal cost of business doesn't create additional earnings for the company. Is that right?
That's correct.
Would the company agree now that it will not seek to amortize these costs in a way that generates additional earnings, either as part of the deferral or at the time of the next rate case?
We haven't made that proposal, but that's certainly something I think the commission could find in its decision. And the company would certainly prefer to be able to defer these costs and bring them forward with that risk. And as opposed to not being able to defer them. So that's a trade-off, I think, that would still be beneficial to the company if we were unable to earn a return, which I think in many cases has been where we've landed in rate cases, right? That we're not earning a return on the unamortized balance. I think, again, all of those issues to be decided in the context of a rate case with all the other puts and takes are appropriate, as all the parties have suggested here. But again, certainly, like the company's preference, number one, is to get the deferred accounting order. And if that comes with a decision that we can't earn on an unamortized balance, that would be preferable to not having a deferred accounting order.
And at the time of the next rate case, I thought I saw some language in either your direct or rebuttal testimony saying you were thinking of amortizing these deferred balances even going forward. Would you agree to the same thing, that we're not gonna, if we do amortize them going forward, you're not gonna be seeking to earn a return on that?
I guess I'm not quite sure what you mean by amortize them going forward. So in the rate case, whatever amount we defer, we would bring forward, and then it would be a decision in the rate case over what period of time to amortize those costs. But same answer, I think, again, is like the company's position has typically been when we're having the cash outlay and carrying that, we seek to include the unamortized balance in rate base, but commission has not approved that other than in very specific cases. So I understand that position.
Okay. Yeah. So yes, we would not be. All right. I think that answers my question. Any redirect, Mr. Mitchell?
Yes, I probably have around 10 or 15 minutes.
Okay.
Thank you, Mr. Berman. I want to start with Chairman's questions, specifically about, why can't you do some of these actions in a rate case? Could you explain anything about kind of the GAAP accounting rules and how they come into play, and whether or not they preclude you from deferring these costs without a decision from this commission?
Yeah, and that's kind of what I was getting at there with the timing consideration for the end of the year. Without an accounting order from the commission, the company will not be able to defer any of these costs for 2024. Even if we get that decision after we issue our financial statements, that deferral will be included in 2025's financial statements. So that was really trying to match this appropriately, drove the timing. But back to the other issue, again, without a deferral order and some order stating that these are extraordinary costs that can be dealt with in the rate case, the company will not be able to defer them. So the O&M expense will hit the financial statements up until there's some decision on how to deal with these costs in the future.
Without an approved deferral could that impact your decision of when to file your next rate case?
It could. I mean, there's a number, as we talked about, there's a number of things that go into that decision. That would be one that could potentially impact it.
I want to turn now to some of your discussion with staff counsel. I want to try to clear up just the record in some of your exchange there. Do you recall talking about how a mistake compares to a finding of imprudence?
I do.
I want to make sure the record's clear here. Is it really the case that any mistake is the same thing as imprudence?
No, I think I was trying to distinguish prudency as the driver for whether costs were recoverable. And prudency is really driven by, did the company make the decisions, a prudent decision with the information that it knew at the time that it made the decision? So one certainly could look back in hindsight and think something was a mistake that was still a prudent decision given the information available at the time.
Thank you for clearing the record there. Could I pull up hearing exhibit 104, attachment RLM2, please? And do you recognize this as the attachment to Mr. Miller's rebuttal testimony?
I do.
And is this showing the premium renewal costs historically going back to August 2014?
Yes.
And you discussed with CEC's counsel about the Marshall wildfire. And I believe you said that that event occurred in 2021.
Yes, correct.
Is it really the case that your premium started increasing on an extraordinary basis right after the Marshall fire, or was it later in time?
I mean, as this shows, there wasn't a huge increase from 21 to 22, which was the first renewal after Marshall. Then it became bigger in 23, and then obviously we can see where it goes in 24, what's at issue here. So no, it was not immediate after the Marshall fire.
Thank you. Can I also pull up the Utah decision here in exhibit 505, please?
.505 is Oregon.
Oh, I'm sorry. Does someone recall what the number is? I must have incorrectly written it down as 505.
I don't think we have a Utah one.
Oh, you know what? We'll press the easy button. I have it in box.com myself. We pull it from box.com. The hearing exhibit pre-marked for identification as 109. And you recall quite a bit of discussion about this Utah decision, Mr. Berman?
I do.
Do you recognize this as the decision that you were discussing?
Yes.
Can we turn to page 9, please? And can we move down to the last paragraph? Could you read out loud the second sentence on that last paragraph going on to page 10?
Although such premiums are expenses of the kind that are ordinarily recoverable, available facts suggest this unprecedented increase is to some significant degree tied to conduct of on the part of Pacificor that an Oregon jury found so grossly negligent, reckless, and willful that it awarded approximately $18 million in punitive damages.
Based on this sentence and your understanding of the decision, was the denial in Utah for an accounting order tied to the fact, to some part, that Pacificor could not show that its Oregon jury liability is being reflected in Utah's insurance premiums.
That does appear to be what this is suggesting.
Can you explain what processes the company has to direct assign costs to avoid similar situations?
Sure, we in this premium and in to a much lesser degree in prior years, the insurance providers provide a direct assigned portion of the premium to each of the company's operating companies. So we have two pieces here. We have the portion the insurance companies have directed as what they are assigning to PSCO. And they have a separate portion which they assign to SPS and Minnesota as well. And then the overarching portion we talked about, which is the more traditional general liability terms, which the company allocates per its cost allocation manual across all of its operating companies. So the portion that's direct assign is primarily related to wildfire, as we've been told from the insurance company.
So hypothetically speaking, a wildfire event in Minnesota would be direct assigned to the Minnesota utility as opposed to public service.
That is my understanding, yes, of how the insurance company's assigning those costs. And so the company's then picking that information up and putting those costs directly to those operating companies and only allocating the portion that the insurance company's not telling us directly where it belongs.
And then just taking a step back from all these Western utility commission decisions.
Your Honor, before we move too far away from the document that council just had Mr. Berman read from, I think that document, if Mr. Berman is to read from it, needs to be moved into the record.
Is it, well, I mean, his oral testimony can stand by itself. Mr. Manchol could move it in or not as he pleases.
I think for completeness, since Mr. Mansholt is relying it for a particular fact, suggesting that a public service company would be able to ring fence the liability of other states, I think it's important to show that the basis for the deferral was that ratepayers shouldn't bear any responsibility for the company in Utah, PacifiCorp's gross negligence and recklessness. And so I think that it needs to be in the record so that the commission has the benefit of context. The sentences that follow the excerpt that Mr. Berman read were particularly important in that regard. And so just as Mr. Mansholt sought to ensure that we had complete decisions entered on CEC's behalf, I think that this too warrants that same treatment.
I think I agree, Mr. Mansholt. Any objection to putting the whole document into the record?
That's fine.
So moved.
Thank you, Mr. Chair.
Just taking a step back, Mr. Berman, all these other states across the West that are addressing some deferral requests, such as what is at issue in this proceeding, what's the point of pointing out all those other actions in those other states?
Yeah, I mean, what I was seeking to do by citing to those other states is just to show that in states where this risk has come quicker and earlier than it has in Colorado, that those states have dealt with it in a number of ways. So whether it be a fund in California, multi-year plans, which many of those states employ, deferrals or other orders that address the risk of wildfire that is rapidly increasing on those utilities. We're just beginning that discussion in Colorado with the wildfire plan, with the company's request there, with this request. So it's to bolster the argument that we really need to be considering that risk in Colorado and thinking about mitigations for it that the company's bringing to the commission to approve.
Thank you. And can we bring up now hearing exhibit 503? Do you recall having a discussion about this presentation with counsel for CEC?
I do.
I believe there were some questions about whether or not this presentation mentions at all insurance cost deferral regulatory proceedings.
Yes, there were.
Can we turn to page 18, please? Can you read over to yourself the top row listed in this table? And then let us know if that refreshes your recollection about whether such deferral cases are mentioned in the presentation.
Yes, it does, and just would say that, as I said with Ms. King, this is a 46-page document, and I didn't recollect whether it was or wasn't. But here, clearly, the company's talking about its ongoing earnings guidance, and the first thing on this list lists constructive outcomes in regulatory proceedings, including the request for deferral of incremental insurance costs associated with wildfire risk.
Does this indicate this is an important proceeding? Our current hearing for the commission?
Yes, and again,
Objection. I think that Mr. Manschultz is asking a leading question with regard to this treatment of this language. And I think it presupposes that this is an important proceeding with respect to the utility's earnings expectation for its shareholders. And so if Mr. Manschultz is going to ask that leading question, that it be made more precise.
I didn't ask a leading question. I asked if this indicates it's an important proceeding.
That works.
So once again, does this row indicate that this instant deferral proceeding for the Colorado Commission is an important proceeding?
yes, I think it does.
Lastly, you had quite a long discussion with CC's counsel about deferral cases that originated and then were reapproved in rate cases. Do you recall that discussion?
I do.
Does your direct testimony also discuss other proceedings where deferrals were addressed outside of a rate case?
Yes, it does. I discussed a few examples related to deferral approved for COVID-related expenses, environmental related expenses at one of our generating facilities, and I believe even another one or two that aren't top of mind at the moment.
If we could just bring it up real quick. Here in Exhibit 101, page 17. That's starting on line 9. This is the section of your testimony that discusses those examples.
Correct.
Okay, no further questions. Thank you for your time, Mr. Berman.
Mr. Miller.
Yes, I'm here.
Can you hold up your right hand?
Yes,
Do you swear to tell the truth, the whole truth, and nothing but the truth?
yes, I do.
Is anybody with you now or communicating with you in any way?
No,
If that changes, you'll let us know.
yes, I will.
Back to you, Mr. Manschultz.
Good afternoon, Mr. Miller. Thank you for being here.
Oh,
Hi, can you please state and spell your name for the record?
yes, it's Robert Miller, RobertMiller.
And by whom are you employed and in what role?
I'm the Director of Insurance for and employed by Excel Energy Services.
And the company filed on your behalf in this case. Here in Exhibit 102, your direct testimony and attachment, as well as hearing Exhibit 104, your rebuttal testimony and attachment.
Yes, that's correct.
Are you aware of any material corrections to those testimonies or attachments?
Nothing material.
The witness is available for cross-examination.
Ms. King, I have 30 minutes.
Chair. Good morning, Mr. Miller. I'm Michelle King. I'm here on behalf of the Colorado Energy Consumers. It's nice to meet you.
Nice to meet you as well.
I'd like to please start with hearing Exhibit 102, page 11, at line 3, please. And if we can scroll down, perfect, thank you. And there you address the question, how does Xcel Energy seek to limit the costs associated with insurance premiums? Do you see that?
Yes, I do.
And it's not there in the question posed, but is it fair, based on the actions that follow, is it a fair characterization to say that the discussion that follows is how Xcel Energy ordinarily seeks to limit premium costs? And we can substitute the word ordinarily with usually or typically or historically at your pick.
Yes, I think it does characterize it. We followed a similar process this year, but it did deviate from this slightly.
Okay, and so if we refer to each of the bullet points that you provide there in that testimony, is it a fair characterization to begin each of those by saying, ordinarily, we use specialized and expert insurance brokers? Is that fair?
Well, let me just take a quick look at them.
Sure thing.
Yes, those are all correct.
Okay, and then continuing, actually, quick question on line 18 to 21, where we would say, ordinarily, we meet with each underwriter in each insurance market to explain the company's risk profile. Do you see that?
Yes.
And just to be clear, as you're using it here, since the question posed was with respect to Xcel Energy, when you refer to the company's risk profile, are you referring to Xcel Energy's risk profile or Public Service Company of Colorado's risk profile?
Well, it would depend slightly because many of our programs are overarching across the entire corporation, but then some other programs are specific to certain territories. But what we're referring to here is our risk mitigation efforts that we have in place to lower the risk.
Yeah, I understand all that, but what I'm asking is, when you're using the word company here, are you talking about Xcel Energy or Public Service Company of Colorado, or both?
Both, yeah.
Okay.
It would be both.
Okay. And so continuing on to the next page, let's just look at those bullet points too, to say it's fair that we would say ordinarily we ensure that our potential underwriters are creditworthy, right?
Right. Yep, that's correct.
Okay, and then down to the next one, ordinarily we have long-term relationships with our key insurance, right? And ordinarily we meet several times a year.
Correct.
Okay, now I think we can agree that we're no longer in ordinary times, right?
Yes, that's correct.
Okay, and you have described the changes in the market as extraordinary and unprecedented. Do you recall that?
Yes.
Now, I'm not saying what you have done before hasn't served the company or its shareholders or its customers historically, but as you testify, it's time to look at other options going forward. Wouldn't you agree?
Yes.
And in the interim, you mention reconsidering the optimization of your overall insurance tower. And we can please turn, if you'd like a reference, to page 11. Actually, I'm sorry, it's hearing exhibit 104 for that reference. Thank you. Page 11, please. Line 20. Mr. Miller, you say that in the interim, you would reconsider the optimization of your overall insurance tower and associated layers of coverage, greater use of Xcel's captive coverage, and use of third parties to inform your actions ahead of next year's renewal period. Is that right?
Yes, that's correct.
And if we can scroll a little further on page 12, please. Thank you. you also propose that the company will file a report by June 2nd, 2025 to keep the commission informed. Is that right?
That's correct.
And then continuing on page 17, line 11, you talk about longer term options, like looking into self-insurance, right?
Correct.
And even as you consider self-insurance, you understand that such mechanisms are complex, especially for the corporate structure of XL Energy that has operating companies in many states, right?
Yes, that's correct.
And longer term, you also mention establishment of a pooled wildfire fund. Is that right?
Yes.
But it's your conclusion that without diminishing the importance of addressing all long-term options, they are themselves complex and unlikely to be rapidly implemented, right?
Correct.
Now, Mr. Miller, you're aware that the company is seeking a deferral mechanism for excess liability insurance premiums that is not limited in the amount eligible to be deferred. Is that right?
Could you state that again?
Sure.
This isn't my specialty area.
That's okay. The deferral, are you aware that the deferral that the company seeks approval of here today is not limited in the amount of dollars that can be deferred through that mechanism? Do you know that?
It's my understanding, yes.
Okay. And is it also your understanding that the deferral the company seeks approval of here today is not limited in duration by how long that deferral will be in place?
Correct.
And so while these longer term options that we've just discussed may not be rapidly implemented, if the company is tagging every unrecovered insurance dollar for reimbursement through the deferral, what incentive will the company have to move quickly towards a better approach in these rapidly changing times?
Well, it's it's an interesting question because I guess my immediate answer would be that we always try to optimize our insurance program. So there'd really be no incentive for us to not do that, and we are very careful on how we structure the program, and that's where we utilize our outside experts to help us do that.
Okay, so if I understand your response, because the company is always optimizing your best insurance options, that we should trust that the company will continue to seek the best options relative to all alternatives, even when it's eligible to recover every dollar that it spends.
Well, I believe that report that we offered to share with you would help prove some of the steps that we're taking mid policy year to optimize that program, and of course that's a ways away from October, so things can change, but that would be our attempt to demonstrate that we're optimizing our efforts.
But Mr. Miller, wouldn't that report only inform what's to come in the subsequent upcoming renewal year, as you testified?
Well, I would hope not. I think, as we've talked, there's a lot of initiatives that are pending from the efforts of EEI and others looking at pooling and, state federal funds and those types of things. But I mean, we certainly would look at utilizing all the tools that are offered at that time and trying to, based on the status of those other products, try to anticipate what our program would look like going forward into the future.
Has the company already started looking into a wildfire pool in Colorado?
I couldn't say the company and specifically, but I've had some discussions with some other utilities on how they've structured theirs. Yes.
So none of those actions are before the commission today. what's before the commission today is simply the deferral, right?
It's my understanding, yes.
Okay. And if the deferral is granted.
Well, let
then-
me back that up a second because
No, I'm going to move on to a new question now, Mr. Miller, and that is if the
Okay.
commission grants the deferral and the company is allowed to tag for reimbursement every incremental dollar it spends on excess liability insurance, what incentive then does the utility have to secure the best deal available for customers?
well, our goal is always to provide the best value for our customers, and that's always been the case. So I think that that's just our standard practice.
And Mr. Miller, are you at all familiar with the term moral hazard?
Yes.
And what's your understanding of that concept?
Well, to put it in, I guess, layperson's terms, you essentially may not have incentive to do the right things.
And so as Oxford defines it, it's a lack of incentive to guard against risk where one is protected from consequences. Do you accept that definition?
Yes.
Now, while the company may assert that the prudence review is where it will face such consequences of potential disallowance, when faced with a simple exercise of expense reimbursement, as can occur in a deferral, how will we, at that point in time, in a rate case, which might be years later, be able to evaluate the road or roads not taken?
I have to object. That's way beyond the expertise of this witness. The regulatory questions involving the rate cases recovery, incentives, and lag were for Mr. Berman, not for Mr. Miller.
May I respond?
Yeah, please.
The witness has said that he is familiar with the concept of moral hazard, and I'm trying to probe whether the company indeed is insulated from any consequences while ratepayers bear the risk, and that might have an impact on encouraging price insensitivity, notwithstanding Mr. Miller's claims that the company always tries to do the right thing.
I mean, you can keep going a little bit, but Mr. Berman was the witness on cost recovery and the financial incentives for the company. So I'll overrule the objection for now, but I think you're pretty much where you're going anyway. So you want to repeat the question for Mr. Miller?
Sure. Mr. Miller, in the course of procuring insurance, you undertake a lot of actions, right?
What do you mean by a lot of actions?
Well, all the bullet points that we discussed that occur in the ordinary course, right?
Yes. Yes.
And if the company is permitted to defer the costs in the deferral as requested here, we heard earlier, were you present during Mr. Berman's cross-examination?
Yes, I was.
And we heard that the company currently has no plans to file a rate case. Are you aware of that?
Just based on what he said.
And so it's possible that it may be several years before the deferred costs are eligible for reimbursement. Are you aware of that?
Just based on what was said.
And so the question to you is, if years go by, notwithstanding all the many actions that you take as described in your testimony, how will we, in evaluating those dollars, be able to evaluate the roads not taken? And you can say, I don't know, that's fair.
Well, I guess I was going to ask, what do you mean by, can you further define the roads not taken?
Sure. When negotiating for insurance policies, you have any number of options available to you, do you not?
We have multiple options, yes.
And if you pursue one option, that means that there are other options that you're not pursuing, right?
Correct.
And so I'm considering the ones not pursued, the road not taken.
Okay.
And so the question to you again is, how will we evaluate years later the roads not taken? So that, to your point, we can ensure that the company did in fact get the very best deal for customers.
Well, it's hard to speculate on what the outcome would be down the road, yeah.
Did we lose Miss King?
I'm sorry, Mr. Chairman, I believe she said no further questions.
Oh, I'm sorry. I didn't hear that.
Did. Thanks.
I lost that. Ms. Crampton.
Thank you. I'm sorry, did staff waive cross of Mr. Miller or reduce cross? I wasn't sure.
I thought they waived, but maybe I screwed that up. Mr. Smith, I thought you waived.
We did, Your Honor.
Okay.
Good morning, Mr. Miller. We haven't met before. My name is Kate Crampton. I am an attorney at the Colorado Attorney General's office representing the Utility Consumer Advocate.
Hi, nice to meet you.
Nice to meet you as well. Mr. Miller, I wanted, let me ask you, there's not a legal requirement for the company to obtain excess liability insurance coverage, correct?
I'll have to object, as Mr. Miller is non-attorney. He cannot provide a legal conclusion or a legal analysis of such a question.
Can you rephrase your question, Ms. Crampton?
Sure. To your understanding, Mr. Miller, is the company obligated to obtain excess liability insurance coverage?
In some cases, it's a requirement on contracts that we're involved with, yes.
Okay. And so that would be related to those specific contracts that the company has that obligation. Is that right?
Yes.
Okay. And if we could pull up hearing exhibit 2-7, or I'm sorry, hearing exhibit 305 from box.com. And if we could just scroll down. And Mr. Miller, you were the sponsor of this response to the UCA's discovery inquiry. Is that right?
Yes, that's correct.
I would move to admit hearing exhibit 305.
Any objections?
None.
So moved.
And Mr. Miller, you were asked sort of a similar question in this discovery question, and I think your response indicated that there may be sort of independent contractual obligations to carry this type of insurance. Is that right?
Correct.
And then you stated that regardless of any legal requirement, the company finds it's prudent to have this insurance in place to provide cost stability and protect customers from risks, including from catastrophic events. Is that correct?
That's correct.
You'd agree that having the coverage doesn't protect customers from having the catastrophic event occur, correct?
Correct.
And in fact, the company's obtaining of excess liability insurance is for the benefit and purpose of ensuring the company against liability to third parties in the event of a catastrophic event, correct?
Correct.
Mr. Miller, thank you. And we can pull down hearing exhibit 305. Thank you. Mr. Miller, in the course of preparing for today, have you had a chance to review the answer testimonies of interveners and respond to them in your rebuttal testimony? Is that right?
Correct.
And in answer testimony, the trial staff in this case distinguished wildfire risk and insurance costs from other circumstances that were deemed extraordinary and outside the control of the company. Is that right?
Could you explain that a little bit further?
Sure. If we could pull up hearing exhibit 400 and at page 12, please. Thank you. And Mr. Miller, I'm showing you staff's answer testimony. And here is where staff in their answer testimony distinguished these excess liability insurance expenses from other circumstances that were deemed to be extraordinary circumstances. Do you recall that in their testimony?
I do, but I think Mr. Berman probably addressed these comparisons previously.
Okay. Well, and if we could just scroll down to page 13 in the top line. And here staff indicated that these costs are neither new or unexpected. Do you recall that?
Well, in general, the costs are expected, but as you stated before, they were higher than what was normal.
That I stated?
Well, it was stated that it was an extraordinary year for the renewal.
Okay. I think you mean by perhaps your colleague in redirect with Mr. Manchel. Is that right?
Well, I think the previous discussion stated that as well. Ms. King.
Thank you. If we could pull up hearing exhibit 104, which is your rebuttal testimony, Mr. Miller.
Okay.
And if we could go to page 10, please. And I'll just direct your attention to lines 11 and 12. And here, Mr. Miller, you testified that there will always be a risk of a low frequency and high severity catastrophic event. Am I reading that right?
Yes.
And I think just to follow up on some of the questions that you had with Ms. King, and we can take this hearing exhibit down. One of the issues with obtaining excess liability insurance from third-party insurance companies is that the company has to be able to negotiate a certain rate with the insurance company that it believes is favorable, correct?
That's correct, yes.
And so the amounts that customers potentially are on the hook for depends on the success of those negotiations.
Yes, that's correct.
And customers can be made to pay potentially significant annual amounts for insurance premiums, even for years when no claims are made. Is that right?
Yes, correct.
Okay, and so along those lines, other states have explored alternatives to obtaining excess liability insurance from third parties. Is that right? Is that your understanding?
I believe, yes, there have been some cases of that.
Okay. And some of those options are the pooled insurance fund that you've heard discussed this morning, or potential self-funding options. Is that right?
Correct.
And if the company were to pursue self-funded insurance, the money could be set aside for the payment of possible losses rather than paying a premium for similar insurance coverage from a third party.
Well, that's correct, but I think there's some misunderstanding of the term self-insurance, that some of the others that maybe are characterized as having self-insurance, they may be utilizing a captive for that. that retention that sits below the state fund or something, and we're currently doing that. We're currently using our captive for a similar purpose.
Okay, I think I may have a few questions for you in that vein, but just sticking on self-funded insurance, as you understand it, under a self-funded insurance scenario, would the set-aside money be saved up for if and when there actually was a scenario of possible losses?
That would be my understanding of a definition for it, yes.
And I'm sorry, if we could pull up Hearing Exhibit 104, page 13, please. And Mr. Miller, direct your attention to table RLM-R-2.
Correct.
And what this table shows is the premium renewals for both all perils and wildfire only for regions without significant wildfire exposure and for regions with significant wildfire exposure. Is that correct?
Correct.
And if the company moved towards or had a self-funding option, would it be able to self-fund for wildfire only possible losses?
Yes, that would be one way to structure the program.
And Mr. Miller, I think you started to touch on this, but what is the difference between the self-funded insurance option, as you understand it, and the insurance and the company's current insurance captive that you described in your testimony?
Well, as you stated, the self-funded would be a pool of money that would be set aside to contribute to in the event of a loss, whereas a captive, is that the term that you use for the second definition, a captive insurance company? A captive insurance company is our own company's insurance company that's regulated by a state Department of Insurance, and premiums are paid into the captive based on analysis by a third-party actuary. And in the event of claims are paid out of that same captive.
Okay, I think I understand. And then another option that you're aware of and that's been discussed here is a pooled insurance fund. Is that right? Like California has.
Yep.
And I think you testified that you've had these conversations, but that's where things stand.
That's correct. I mean, we're waiting on results from some of the efforts through EEI and other groups that are looking at that option to provide a tool for us to utilize.
And a pooled fund like the California Wildfire Fund and a self-insurance option are not the same, but they can work in a mutually beneficial manner. Is that right?
That's correct.
Okay. And that's what you stated in your rebuttal testimony, correct?
Yes.
Okay. Mr. Berman testified earlier this morning that the scope of the proceeding today is limited to the issue of whether or not to approve the deferral and tracker, but then you indicated in your rebuttal testimony that there's also a willingness to include in this proceeding a report prepared by the company regarding exploration of mitigation of costs. Is that right?
Well, I think it's optimization of the insurance program is maybe a better way to say it.
Okay. And optimization to theoretically mitigate these costs.
Correct.
And and to provide transparency during this evolving period to the commission and presumably interested parties. Is that right?
Yes, that's correct.
And you indicated in your testimony that the company would work with a third party to prepare that report.
Well, multiple third parties, yes.
Okay. And this report is meant to demonstrate the efforts that the company is taking to, as we've said, mitigate the cost of this insurance.
Correct.
If the commission were to deny the request for the approval, is the company still willing to explore these options to mitigate costs and provide reporting to the commission regarding those efforts?
I guess I can't, I don't have enough experience in that area to be able to tie the outcome of a decision to what our actions on the insurance side would be.
Okay. And would the company be willing to explore and discuss the results of a self-funded option in any June 2025 report?
Well, my preference is still to utilize our captive rather than a self-funded type program, and I can explain why that is. Well,
let me jump in here, Mr. Miller. My question is not about the company's preference, but rather whether the company be willing to explore and discuss the results concerning a self-funded option in a June 2025 report.
Yes, we'd certainly do that. That is an option. So we would compare that to all options and determine which is the most optimized, correct?
Okay. And likewise, and I can maybe anticipate your answer, but would the company commit to exploring and discussing the results of a wildfire pooled insurance account like California has in the proposed June 2025 report?
Yeah, we're going to explore all options that are available to us and even try to, as I said, try to anticipate looking into the future as more options develop.
Okay. I appreciate that clarification. I don't have any further questions.
Thank you, Commissioner Plant. Any questions for Mr. Miller?
I do not.
Commissioner Gilman?
I do have a few questions for you, Mr. Miller. Good afternoon.
Thank
So you provided an attachment, and we don't need to pull it up just to save time, but in hearing exhibit 104, attachment RLM2, you show the history since 2014 of the excess liability premiums. And I was curious, is there anywhere I can reference to find the actual coverage limits? Help me out if I'm getting the terminology wrong, that this would relate to in terms of that excess liability policy that these premiums relate to.
I'm trying to think. I mean, it's out there, obviously, but I'm trying to think if it's publicly available information. I don't believe it is.
Okay. Has it been provided to the commission or the parties under confidentiality or in any other way?
I can't recall if it has or not.
Okay. Do you have a concept of how the coverage limits related to the excess liability policy has changed over the term since 2014?
Not all the way back to 2014, but in more recent years, it was relatively stable, and then it started to drop a bit, almost in concert with when the pricing started going up. The limits started to drop a bit.
Okay. So is it your understanding that these higher premium policies also carry lower coverage limits than historically?
Yes, that's correct. Historically lower.
Okay. And then curious about any of the other terms related to the insurance policy and how any kind of material terms change as we see these premiums increase. Have any of those terms become kind of more generous or less generous to the company as it would relate to coverage under the policy?
I mean, the only material change has been on wildfire. There's been some wildfire sublimits or wildfire exclusions.
Okay. Are those detailed anywhere in this record so we could understand those?
No, I don't think they are. They wouldn't be specifically obvious, except in an insurance program tower where you see layers that shrunk, where in the past they offered more coverage and now it's less. But I don't believe we provided that in this filing.
Okay. So I know you're not a lawyer, but you know probably a lot more about insurance policies than I do. So just a question for you on what I presume is probably a pretty basic term. If we presume if the company were found liable to some degree financially for damages in the Marshall Fire, would any financial responsibility be covered by insurance policies in place at the time of the event, or those that would be in place at the time of the judgment?
Well, it's tough to speculate on an adjustment of a claim. Each one is different. You can't even typically get an insurance company to speculate on that. There's a lot of factors that go into adjusting a claim, so it really needs to be determined at that time.
Would it ever be applied to the policy as it was at the time of the event rather than the current policy?
Maybe I don't understand that question.
Just trying to understand if the terms of the policy changed between 2021 and
Gotcha.
2025, which terms would be relevant in a judgment that could occur in 2025?
Sorry, I misunderstood your question.
No
So
worries.
it would be the policy in place at the time of the event.
At the time of the event, I'm sorry?
Yes, at the time of the event, yes.
Okay. Let me see, 1 second. So I wanted to go back to just something I heard in Mr. Berman's discussion on the allocation of the excess liability coverage among the operating companies.
Yeah.
As I understood his testimony, it sounded like the insurer more or less told the company some allocation, perhaps based on buffer activity or claims. Did I get that right? That the insurer provided some information as to what that allocation should be to some degree among operating companies?
Yes, they do provide allocation guidance for us.
Okay, and is the allocation guidance further broken down in terms of risk at large versus claims history?
Yes, it is.
Is that information in this record anywhere?
I don't recall. I believe there may be a table with that.
Okay, so just so I'm clear, public service does possess information as to the allocation related to the excess liability insurance premium based upon claims history versus risk more at large.
Yes, and it's really not just based on our risk. It's based on the regional risk. The insurance companies have identified states within a higher risk area, and they assign a wildfire load to those states. And we just happen to have operations in that state.
Okay, but the claims history piece would be specific to Public Service Company of Colorado?
That's correct, but it's a very small piece in this case.
Okay, but we're not sure if it's in the record.
No, it is a document in the record. I just couldn't point you to it right now.
Okay. Let's just see. Does the company have any information, either from your insurer or from other peers or just publicly available information as to changes in excess liability premiums that other electric utilities have faced over the same timeframe?
We get some benchmarking information, yes.
Okay. Is any of that in this record?
No, not in this record, no.
Okay.
I don't believe.
Have you had any discussions with your excess liability insurance carrier regarding the company's wildfire mitigation plan that's currently pending before the commission?
Yes, we did. We were kind of in the thick of our renewal trips and meeting with the insurers when that was being filed, and it was very well received. I mean, it's hard to have a direct tie to their quotes, I guess, but they certainly had favorable responses to it, and I believe that we did see some preferred treatment based on that plan being in place, and in particular the safety shutoff that happened in April. That was kind of real time. It happened while we were talking to these folks, and they were very, very impressed that was done the way it had been done.
And what do you mean by favorable treatment? That perhaps we could be looking at higher premiums, or what?
Well, I think, it's the building of an insurance tower is really quite delicate because we have many insurers up the tower, and they're comfortable with being at a certain attachment point. So as you build the tower up, you have to pay one layer out before it goes to the next layer and the next layer. So this year we had some of our mutual insurance companies cut back their wildfire coverage. So it was trying to force some of these other markets down where they didn't want to be. So it was very difficult to do that. And one of the mutuals that we deal with, they have guidelines on how much they'll provide for Western states, and they actually gave us preferred treatment and provided us more limits in Colorado than we would have expected, I guess. So that was an example of that. Okay.
And is there any indication from any of these insurers that the outcomes there will have a bearing on their insurance premiums in the future?
Could you restate that?
Is there any indication from any of your insurers that the outcomes there in the wildfire mitigation plan will have any bearing on their premiums in the future in any kind of predictable way?
No, we didn't get into the likelihood of the outcome of that filing.
Okay. Those are my only questions. Thank you.
Thank you.
Thank you. I don't have any questions. Mr. Manshall, redirect.
Yes. To start, Mr. Miller, thank you for your testimony. Seems as though when you were discussing some questions with counsel for UCA, you want to talk a bit more about why you think company's captive is either the better solution or a similar solution as self-funded insurance. So is there more you'd like to say about that?
Yeah, and I guess just as I was speaking with Ms. Gilman, that the structure of the insurance tower is quite delicate, and when we had some gaps that we needed to fill, we utilized the captive to fill those gaps. And if you went with a self-funded type program, you wouldn't have that captive to fill those gaps. So then you would truly have gaps in coverage, or you would be forcing markets to move down in the tower down further than they would prefer, and it would drive up the cost significantly.
Can you just talk a bit more about how the company seeks to maximize the benefit of the captive for coverage and premium costs?
Well, we had a good example this time, and it really was the main driver with requesting the extension on the renewal date from October 18th to October 26th, because there was a market that typically would fill in a layer on our program, and they were significantly overpriced for filling in that layer because it was down lower, as I mentioned, down lower than they would typically like to attach. So we utilized the captive to fill in that gap, and then they were pushed up a little bit further, and their quote went from 53% rate online to 30% rate online. So we saw a significant savings there.
Thank you. And you also had some questions about benchmarking cost data with other utilities with Commissioner Gilman. Can we pull up rebuttal testimony here in Exhibit 104, please? Turn to page 13. Go down to the table on this page. Is this what you were thinking of about where we provided some benchmarking data for other utilities in the record?
Yes, this would demonstrate that. I guess one thing that's not captured here is, as I had a discussion earlier about the limits reducing slightly as well. That was also a common occurrence with other utilities as well.
Okay, and I will say that for Commissioner Gilman's request about getting more information of direct allocation costs, does it help to refresh your recollection that the company provided such data through the discovery process in this case?
No, I believe I did clarify that and said that there was a document that was provided.
Yes, and the company can work to supplement the record if that's what Commissioner Gilman wants on this. But we would just need a little bit of time to make it for Box.com as a confidential attachment, if that's what the commission would like on that front.
Yeah, I think we would like it.
That's the end of my redirect, but we are continuing to work on this confidential attachment for Box.com.
That'd be great. And if it's after the hearing, and if you could just run it by other counsel and make sure there's no concerns, that'd be great.
Will do. Thank you, Mr.
Miller. Staff witness, thank you, Mr. Miller. You may be excused.
And the company can waive its remaining cross times for all of the other parties.
All right. I think that concludes the hearing. Are there any other matters? I think we'd have the statement of positions due on December 11th, consistent with the schedule we adopted in our prior order. Any final matters before we close the record and adjourn? Ms. King, Ms. Crampton, Mr. Smith?
And from UCA. Thank you.
Well, thanks for getting us in under the deadline. Didn't seem possible from the initial cross matrix. Appreciate the thoughtful conversation. Anything final from you, Commissioner Plant?
No, nothing from me. Thanks a lot.
Commissioner Gilman?
Nothing, thanks.
All right. With that, we're adjourned. Thanks all.
Thank you.
You.